Pardon to make a mention, my lordship. Live convict, lordship. Convict and 302 IP 3. Appeal for bail is more than 11 years. Another jail criminal appeal to jail.
One DRT. One DRT matter which is pending before DRT, but I have already deposited the all outstanding dues. But even if that I have deposited, bank is now imposing and DRT is not hand over the amount to bank.
I don't interim application there.
I have filed two applications. One was
But
rejected,
can we
one
do?
is pending.
Matter is sub judice there, and you are to supposed to take steps for early hearing of the interim application. But
That
you can-
rejection, interim application rejection, I will challenge and I have to.
Interim application rejected, then alternative forum is available. Against the order of the DRT, DRAT is there. We are not to hear this matters.
That seem hard.
Give the memo, there is no problem. Yes.
Weekly list item number 1.
Item number 1 is the fresh admission matter. My lord, there has been some subsequent development in this case. So, my lord, I require some time to file an affidavit. It's on.
That you have stated on 19/6/25, 2 months
Yes,
back.
the affidavit is with us, my lord. We are in the process of filing it. Yeah.
Let me go. What is your good name?
My lord, Krutivash Mahapat.
Mr. Kutivas Mahapatra, Land Council, appearing for the petitioner submitted that in terms of the order dated 19/6/2025, he has not yet filed the supplementary affidavit and some more time is required. Put up this matter, give a date. Yes, next.
Item 2.
This true. And you have last parallel also this certified, inter-certified copy was called for.
Yes, sir.
They have instructed, but they have applied with the record of consent record. They have requested for 2 weeks.
Please come to the operating. Submitted that state was not given any opportunity to file counter affidavit. Where? Administrative tribunal.
State administrative.
Directing the pay of the opposite party to be revised and last pay to be determined, so and so. It appears from the imprisonment order that the said order was forwarded to all concerned. Further appears that not only there is inordinate appearing approaching this court. Oh, you are challenging the order
Yes,
dated
yes.
2018.
That is in a.
Further appears that not only there is inordinate delay, but also in the meantime, policy decision has been taken by the government over the issuing of council. Was not given any opportunity to file the counter affidavit. The matter was clear and it was disposed of from where the land council for the state produced the order switch. To substantiate his argument, yes. So,
They have
what you have
requested
done?
only 2 week time they have requested because they have asked. The record has been consent to the. I pray for 1 week after so that.
This order must have been passed here. Because लिखा है जी ऊपर लिखा है आर मिस्टर बिंबिसार दास लैंड स्टैंडिंग काउंसिल वाली प्रथम पैराग्राफ में ही लिखा है जी इज इट ऑर्डर नंबर 1
Yes, order number नहीं सटीक order का मेंटेन है जो दिन लिस्ट रे मेमो है कैश वेट रे थला से दिन लिस्ट रे डिस्पोज ऑफ है
No.
तो स्टेट काउंसिल जो अप्लाई करना नाटा रिकॉर्ड था
The original application is of the year 2018
18
and it was disposed of when
27/11/18
27/1. So suppose prior to that notice has been issued, you are given opportunity of
ट्रिब्यूनल ने नोटिस है तो स्टेट काउंसिल का था मैंने कॉपी टा सर्विस हुई
for that we actually required your
only I pray for 1 week so if not provided then on merit because there is inordinate delay the entitlement eligibility on
the land council for the state seeks some further time to file to produce the order sheet of the Land and Orissa Administrative Tribunal Bhubaneswar in way number 2850 of 2018 to substantiate his argument that the state was not given any opportunity to file the counter affidavit and also to explain the delay in approaching this court, which was almost 6 years. Put up this matter on the included date. Yes, next.
Item 3.
Mr. Jinnah. Oh. Item number 3.
এটা বি স্টেট, এটা স্টেট।
এটা কি আপনার তো?
2, 3, sir.
2, 3,
Right.
আচ্ছা।
Then why these names are appearing Sangram Kesari Jinnah?
Because this state council was filed by name, but
No, now it is to be changed or
Yes.
is the same name is to be
no,
retained?
no, she has.
Is he now the AGA? This,
And he is not in panel.
then why his name will be reflected? The name of Mr. We are mentioning your name then. The name of Mr. Aurobindo Mahanti, an additional standing counsel, be mentioned in place of Sangram Kesari Jinnah. In a approximately, it is stated by Mr. Mahanti that Mr. Sangram Kesari Jinnah is not now in the state panel.
Item 4.
My lord,
Mr. Samontray.
my lord, this matter may be taken up one week after next week.
This matter transfers only in Mr. S.K. Samontray.
My lord,
On Central Government Council तो ठीक है तो?
my lord, my lord.
Government Council 6 some more time. Have you filed your appearance memo?
My lord,
पण सेटा भी फाइल करिया पे 19/5/2025 ରୁ ସମୟ ଦରକାର।
my lord, I will today, my lord, today.
6 for an adjournment लिख दो।
Item 5.
Yes, it is also your matter.
My lord, in this case, item 5,
Yes.
item 5, I have already filed a consolidated petition.
The interim application has been allowed for filing that.
Item 5, read petition number
Just a
135.
minute. 14/7/25, your interim application for amendment has been allowed.
My lord,
So you are required to file a consolidated writ petition
my lord.
that you have not yet filed.
This is, I have already filed on 13/8/2025.
Oh,
That
that
has
is
been
not on
approved,
record.
but no,
That is not on record.
yes, my lord, but
No, it's all right. Mr. M.K. Pati, Central Government Council, no?
senior panel.
Senior Panel Counsel, appearing for the Union of India, submits that after the interim application for amendment of the writ petition was allowed by order dated 14/7/2025, he has filed the consolidated writ petition on
13/8/2020.
13/8/2025. Let the registry place the same on record. Put up this matter, give another date. Yes, next.
Item 6.
Yes, Mr. Mahanti.
May I please report? Order of the Central Administrative Tribunal is under challenge. That is Annexed 4.
Who is to appear on behalf of the Union of India?
My Lord, Union of India.
No, no.
No, that is NALCO is your lordship, Mr.
Yes, the contesting party is NALCO. my
I am
lord.
appearing to NALCO. I have already filed my vocal.
Have you served a copy?
No.
No, I have not.
Served a copy.
My Lord.
You are appearing for whom?
Opposite party 2 to 5, NALCO.
No.
But okay. Mr. Tanmay Mishra, Land Council submits that he has already entered appearance for opposite party number 2 to 5.
2 to 5.
But he has not been served with a copy of the writ petition. Stop. Mr. Mahanti, Land Council for the petitioner, undertakes to serve the
Yeah.
copy of the writ petition by
Tomorrow,
tomorrow,
my lord.
by tomorrow. Next week or so.
Next.
Most of this matter.
So please.
Item 7.
Yes, Mr. Mahanti?
One of the cat, photography on the challenge, I was just him.
Who is appearing for the Union of India?
My lord, I'm appearing.
Have you received the copy of the writ petition? That was the order last time.
My lord.
I thought,
Okay, yes. What is your prayer in this writ petition?
there is to set aside the order passed by the non-cat.
Annexure 14 you are challenging.
Yes, sir. On the ground of limitation, the original application filed before the learned tribunal was not.
Come to the operative portion of the order,
Yes, ma'am.
paragraph number 8, page number 64.
Yes. We have considered the rival submissions of the parties with reference to the pleadings, materials placed in support of thereof, so also the arguments advanced, keeping in mind the law enumerated as discussed above. It is on the record that notification for recruitment to the post in question was on 28/2006. Applicant along with the others appeared in written test on 7/10/2007 and PET on 4/4/2008. The result of the PET was published on 20th of January 2010. Soon after the rest certificate verification was started, but according to the applicant, he was not called for such verification. But it is not in dispute that he sought information under the Act in 2015, that is 5 years after the declaration of PET result, and approached the CAT Patna bench partner, which was dismissed on the ground of jurisdiction on 23rd February 2016. Thus, the very approach of the applicant before CAT Patna bench was obviously beyond the period of limitation provided under the Administrative Tribunal Act. As admitted by the applicant, he approached this tribunal after 2 years and 10 months of dismissal of the OA by the CAT Patna bench. The grounds as ascribed by the applicant for the delay is his illness and illness of his mother, but nowhere it is stated that applicant is completely bedridden for the aforesaid period, which disabled him to file the OA before this bench. Besides the fear of the applicant to qualify information provided under the Act, which is also beyond the jurisdiction of this tribunal. Further, the matter relates to the and appointment to the post as per notification issued in the year 2006, and thus interfering the matter at this distance place without sufficient reason would entail to unsettling of a settled matter and at a distance point of time. Be that as it may, for the discussions made above, since the grounds assigned by the applicant to overcome the law of limitation does not sound the judicial conscience, we are not inclined to condone the delay so as to enter into.
What is the fault in the 2006?
2006, the advertisement was made.
19 years have passed and you are filing.
2006, the
No,
advertisement.
what is the fault? Is it the fault of the that you approach Patna bench and
Patna
then
bench-
Patna bench said that we have no jurisdiction.
Patna
Then
bench-
2.5, 10 years, 2 years and 10 months you approach the. So this is sheer negligence.
What has happened, my lord? 2006, admittedly, the advertisement was made for 5,200.
Thereafter, how many advertisements must have been made for this end? No,
What has happened?
that was for a particular period that already over, that must have been filled off. So why 19 years after we'll entertain this?
I be permitted to submit the. You know, 2006, the advertisement was made. And he was, admit card was his application being found in order. The application, he was called to appear the written test. He qualified in the written test. Thereafter, the PET also, he was.
Now you
qualified.
are, the present age of the petitioner is 52 years. What will do if you are appointed as PT? Huh?
No PET, man. PET.
Or whatever it may be, there is an age limit. How can you be given appointment at the age of 52?
Yes, here, my lord, the injustice has been done. What has happened, my lord? He cleared the written
Everything
test
has
as
a
well as
time
the
to
field
challenge.
test.
Provided you
Physical
seek
efficiency-
your right in right time. If you see, indolent has no,
No, after-
unless you become vigilant,
Unless-
no court will come to your rescue.
Unless- Although the notification was made for recruitment in 2006, but it completed in 2014, my lord. That
No.
I have admitted. In the
Only a vigilant can assert for his right, not an
2014 the
indolent.
appointments completed, my lord. When the petitioner was not called for certificate verification, he sought for information under the Act.
After how many years?
No, my lord, 2015.
15. So,
2015.
hmm.
Immediately thereafter, he approached the partner because
Oh,
the
that is
petitioner
after
belongs
5
to
years,
Bihar,
yes.
my lord. Petitioner belongs to
He is
Bihar.
sleeping over the
approached
matter.
partner.
He knows
Partner
that.
gave him the liberty to approach the appropriate
Look,
person.
this writ petition has been filed by the petitioner Vipin Kumar challenging the order dated 28/8/2024 of the Land and Central Administrative Tribunal, Cuttack Bench, Cuttack, passed in OA number 846 of 2019. The petitioner approached the Land Tribunal with the following prayers. The prayer Lekai 58 of 59. Along with the original application, he filed a miscellaneous application by MA number 136 of 2022 to condone the delay in filing the original application. The Learning Tribunal, taking note of the ratio let down by this court in UI and others versus Vishwanath Moore in WPC number 6268 of 2021, has been increased to hold as follows. Quote entire paragraph number 8. On a bare reading of the operative part of the order, it appears that the petitioner was not vigilant and he has not sought for remedy at right time. Even after the CAT Patna bench partner dismissed the matter on the ground of jurisdiction on 23/2/2016, he approached the Central Administrative Tribunal, Cuttack Bench, Cuttack, after a gap of 2 years and 10 months. The delay in approaching the court has not been satisfactorily explained. Moreover, the selection and appointment to the post as per the notification was issued in 2006. Therefore, we are of the view that there is no infirmity or illegality in the informed order. Accordingly, the writ petition being devoid of which and dismissed. We are not vigilant or achieve patients that we will be put away.
One submission
Should not be done. Whoever not be done, he cannot be. Yes.
one submission.
Next.
Item 8.
Item number 8.
From 8, my lord, beg your pardon, one password may be granted. Scenery journal next.
The matter may be fixed next week, my lord. Next week, that's week.
The Land Council for the petitioner seeks for an adjournment. You are for the
They are petitioner, I am the respondent.
The Land
I'm the
Council
opposite
for
party.
the petitioner seeks for an Union of India is present so also. Put up this matter next week. Yes, next.
Next week.
I beg your pardon, my lord. One password.
Item 9.
Item number 9.
Permitted to
File a memo.
with a liberty to approach the appropriate forum.
The Learning Council, Mr. Misra, appearing for the petitioner, files a memo. We draw the writ petition, that's the language that they feel exactly. Memo is taken on record, disposed of as wisdom. Yes.
By
Lordship, with
permission,
Mr. Yes.
Tunas was present. I'm
Next.
on behalf of Sir Tunas.
Item
Already
number
filed the-
10.
Item 10.
Yes, item 10, Mr. Mahapatro.
It's a passable matter in this case.
Next item.
Item 11.
My lord, it's a matter with the Ronit Senior Advocate, Mr. SP Mishra has been engaged matter. Your lordship may kindly pass over matter, please.
No, next week, no.
Your lordship may call it tomorrow matter.
No question of.
And
only
in
the
this
different
case,
banks.
I have instruction to appear for the bank, my lord. The sale has been occurred and the possession has been taken as per instruction.
We are just mentioning, file an affidavit or something.
Yes, my lord, I will file.
Is stated by Swansea that he has instruction to appear and he will file his wakalatnama
Wakalatnama by tomorrow.
by tomorrow. And he further submits that self certificate has been issued.
Yes.
Put up this matter.
And
next week.
just now, instruction received that possession has been handed
And
over.
possession has been handed over. Put up this matter next week. I-11 item, self certificate has been issued, possession handover. Next week, you will file the affidavit.
A copy of the writ petition.
Copy of the writ petition be served on the land council.
Right, I would like to add one thing, if not indicate, we are ready to pay the entire amount for it.
All right, let him first bring that, those on record.
After sale, then can happen.
Yes, next. Because you are to add another party.
Again.
Yes, next.
Item 12.
Mr. Ojha,
May I please, lords?
yes,
This is against the order of London Central Administrative Tribunal. London Central Administrative Tribunal rejected my interim prayer. That is at page 133, my lord. Now I am not so much concerned with that interim prayer, but while passing this order, my lord, London Tribunal has virtually passed the final order so far as way is concerned. My lord, I am on central deputation for a period of 5 years, which was completed on 26/2025, my lord. Before 6 months, my lord, I made the application to the government as per the central staffing.
we'll restrict that so far as merits of concerned, any observation made in this MA shall not.
Not MA order. This is interim application separate file when clause 9 interim application.
No, any observation made in this order will not be a bar for the to adjudicate the matter on merit. That would suffice.
Because London Tribunal already held that the deputation, she has no right for deputation.
No,
Even if that rule is there, and not only one paragraph, may I point out, London Tribunal misdirected, indicating that I am on inter-cadre deputation. I am on central deputation for 5 years because inter-cadre deputation 5 years is maximum. So far as central cadre deputation 7 years is maximum, my lord. And my interim prayer was rejected, only indicating that it is inter-cadre deputation, therefore prayer cannot be accepted. If your lordship will look into the rules, my lord, rule is clear, my lord. That pays, my lord.
We are not going to pass any observation because in the merit that matter is pending. If you said that you give the observation that has been given, now we will give the observation on the merits of the original application.
But that observations of London Tribunal will not be taken into
Right,
consideration.
that is all. That's all. That's what we will do. Second, the writ petition has been filed by the petitioner challenging the order dated 31/7/2025 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, in way number 268 of 2025. The London Council for the petitioner submits that by passing the impugned order, the some of the observation which has been made while passing the impugned order has made the original application practically infructuous, and the London Tribunal has touched some points on the merits of the case which he ought not to have done while passing the impugned order. After going through the impugned order and hearing the Land Council for the parties, we are of the view that since matter is sub judice before the London Central Administrative Tribunal who has directed the respondents to produce some files before filing the irregular counter, and directed the completion of pleading by 24th October 2025. This court expects that after the pleadings are completed, the matter will be taken up at an earliest for final hearing, and any observation made in the interim application on touching the merit shall not be a ground to reject the prayer made in the interim application, and the learned tribunal is at liberty to take a different view after considering the pleadings and hearing the respective parties. Accordingly, the writ petition is.
My lord, I have a small request, my lord.
Yes.
Let's you reply to file the counter with the relevant records if necessary, man, and with the sealed cover.
No.
Some documents may be there, is required to be filed in sealed cover.
It is to be filed before the London Central Administrative Tribunal.
That's why I'm telling. Is
No,
necessary,
we
then
are
it
not.
can be.
The paragraph number 15 says that to direct the respondent to produce the so-and-so before the so-and-so does not sound the judicial appeal that has been rejected. So, that has been turned down, and the completion of pleadings have been made. So, if any during course of the hearing, any observation made in, set a stand for you. Yes, next.
Okay.
Along with Mr. Panda is appearing.
Deputy Solicitor General submit that in case the production of the file number so and so is necessary, the respondents will definitely produce the same before the
Sealed cover.
in a sealed cover. Yes. Next.
Appearance may be.
Jay Panda.
Yes. Central Government Council na special.
CGC.
Okay.
Item 13.
The order passed by Tribunal Court dated 5/9/2024 has not been complied, even if it is sent by registered post, and they have received it on 19/9/24 on and 20th/9/20.
Two diction two paragraph में.
मतलब
अच्छा, received by them. कितने दिन time दिया इतना?
मतलब 3 months.
Order is dated
5/9/24.
ଆପଣ ଦେଲେ କେବେ?
ଆମେ ତାଙ୍କୁ ପଠେଇଲୁ 18/9 ସେମାନେ ପାଇଛନ୍ତି 19 ଆଉ 20 ଦି ଜଣ ଯାକ both the opposite parties.
There are 3 months. You ascertain the status of that representation, Mr. Naik or Mr. Mahanti. There was a direction that representation is pending and it is to be disposed of in accordance with your law within a period of 3 months from the date of production of the certified copy. That certified copy, all other things were sent by postal receipt, they have received it, and that period has already elapsed. So he has not received any communication. So we want the status of the representation. This content petition has been filed by the petitioner so and so for non-compliance of the order dated 5/9/2024 passed by this court in WPC number 20904 of 2024. While disposing of the aforesaid writ petition, this court has been pleased to observe as follows, taking into account the paragraph up to on the merits of the paragraph of test. It is stated in the content petition that as per the aforesaid order, the petitioners sent the order to the opposite party by registered post on 18/9/2024, which was received by them on 29/2024 and 19/9/2024 respectively. And he has also annexed the copies of the postal receipt and track report showing the sending and receipt of the order under Annexure 2 series stock. It is the contention of the Land Council for the petitioners that in spite of receipt of the order of this court within stipulated time, no order has been passed in terms of the order passed by this court. Stop. So at this stage, Land Council for the state seeks some time to obtain instruction relating to the status of the representation. Put of this matter. Put a subscribe for that.
May if you one extra copy may be solved because
Okay, even extra copy, let an extra copy is sent. Next. And Mr. Das for the Land Council appearing for the petition. 1 week after voting. You have the copy.
There are sorry.
Yes, next.
Item 14.
14.
In my opinion, the non-compliance with the order dated 26/11/2024.
First one to देखते हैं केबे order कहला
26/11
time केते दिया इतना 3 मास केबे जणैले government कहीं postal receipt का चंदा अपन postal receipt पठेले 9/12/2024 से 10/12/2024 से receipt कले अच्छा इसी कॉमन से टाइप में करी
According to a notice was issued.
हाँ
According to that notice was issued to the petitioner. This is Annexure 3.
No, that, but thereafter you have to dispose of that representation. Notice issue कर देल तो हमनी come to that order operative part. The pendency
Kindly see Annexure 4.
No, 13/2/2025
Would you
से
love
तेईस
to
शादी
be rejected?
within a period of 3 months from the date of so communicate the result thereof. You have not communicated the result thereof. That is the grievance. You have just issued a notice.
Should I kindly see Annexure 4 for me?
Yes.
Annexure 4, the concluding paragraph. In view of the fact and circumstances, the petitioner may not be eligible for the payment of rehabilitation assistance benefit as an affected family under the Odisha Rehabilitation Resettlement Policy 2006.
comply कर दी
Has
So it is
already-
complied. Why are you saying that it has not complied?
It is a press cause of action also.
You have to challenge this order. Look on the CP number so and so. Filed for non-compliance of the order dated so and so. However, we find from annexure number 4, which is dated so and so, the zone officer so and so, wherein it is mentioned in the operative portion as follows. Quote, it is not out of place, say to lekhi debe, up to last paragraph, for example. Second page, page 17, last 2 paragraphs, quote, for again, press kar debe, since in view of the order passed, a fresh cause of action arises, we are not inclined to entertain this consent petition, accordingly stands dismissed. Yes, next.
Item 15.
Mr. Bari.
It was the same.
Same.
Yes, other.
But here,
No, it was same, say. In view of this so and so, so. Other say type of कर दोगे, है ना? State is not out of place room. We last 3 paragraph कर दिया तो same order, like the previous one. Dismissed.
Item 16.
Yes.
Which order?
Running page 11, your lordship, operating person.
Running page 11. So also taking into account the petition on the was rejected and otherwise the meantime the decretal deal has been sanctioned by the set aside the order. Under so also has to faithfully adjudicate the matter in accordance with a period of 3 months from the date of production of the certified copy. They will produce
Annex running page 12, 18, 4 to 35.
Government could नहीं change.
Abandonment paragraph 3, your lordship.
Paragraph
3.
they will produce 18/4 तक रिमाइंडर देइछन 26/6 26/18/4 18/4 लगे हम केते मास भीतर देइतलु की
नोटिस ताकर आछि जे आपनको WPCN को ये करके ସେମାନେ ଦେଇଛନ୍ତି ତ
ନାଇଁ
notice ଟା ତ ଦେଇଛନ୍ତି annexure 2 series ରେ
Next two time move ଦେଇଛି
ଆଚ୍ଛା ତାପରେ ଏଇଟା କଣ annexure
ଏଇଟା ସବୁ application ଗୋଟେ annexure କରିକି ତା ଦେହରେ ଯୋଡ଼ିକି ଦେଇକି ମୁଁ 28
ଏଇଟା ଆପଣ ଦେଇଛନ୍ତି
ମୁଁ ଦେଇଛି
ଓକେ ତ ତାପରେ କିଛି ଆଉ communication
ନାଇଁ
ନାହିଁ
କିଛି communication ନାହିଁ result
ଆଜି ନିୟନ୍ତୁ instruction ନିୟନ୍ତୁ this content petition has been filed by so for non-compliance of the order dated 15/4/2025 passed by this court in WPC number so. From the impugned order, it appears that they disposed of the impugned writ petition holding as follows, paragraph number the land counsel for the petitioner referring to paragraph number 3 of the content petition submits that the petitioner filed an application before the opposite party number 3 on 18/4/2025 physically annexing the certified copy of the order dated 15/4/2025 aforesaid order as well as before the special land acquisition officer which was received by the authorities concerned on 18/4/2025 and since in the meantime the time stipulated by this court is already over and the petitioner has also filed another application of the reminder before opposite party number 3 on 24/6/2025 for disposal of the application under section 28A of the LAR. Land counsel for the state seeks some time to obtain instruction in the matter. What is सप्ताह पर रखुची देखो
17
2 weeks after
2 weeks after এইটা ও সেটা দিদা দেখতে matter
same date same
instruction time 2 weeks after
another similar content may be listed along
सिर्फ मेमो फाइल कर दियो आधी आधी तो लिस्ट करियो फाइल
ଆଜି ସେଇଦିନ ଆସିବ ଲିଷ୍ଟ ନମ୍ବର ଗୋଟା ଦେଇଦଉଛି ସେଇଦିନ
ତା ଦେହରେ ଇନଷ୍ଟ୍ରକ୍ସନ ନବାକୁ ପଡିବ
ତାଦେରେ ଅର୍ଡର ଟା ହେଲେ ସିନା ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ why not filing a memo what is there
yes
memo ଟା ଫାଇଲ କରି ଆସିବ କଣ yes
Item 18.
no there is only so once we go to the criminal matter there is only one writ petition left that is item number 10 Mr. Mahapatra State of Odisha has filed this writ petition.
that is the Union of India wrong in that respect Odisha
Oh, short for Passover.
one CGCR short for Passover
No, we'll take up the next week for example. Next week for example. Yes, next.
Item 18.
Passive.
What order was passed previously?
State has produced.
कितने वर्ष ରହିଲାଣି?
Taken on the court this week sometime in the public concern.
Custody certificate. Custody certificate. ଆପଣ produce କଲେ କେତେ ଦେଖୁଛି?
14/7/2025 custody certificate and antecedent.
ହଁ କଣ ହେଲା କହୁନାହାନ୍ତି? କେତେ ବର୍ଷ ରହିଲାଣି ଆଉ criminal antecedent ଅଛି କି ନାହିଁ?
There is no antecedent.
No antecedent, okay. Custody certificate କେତେ ବର୍ଷ ଦେଖୁଛି?
Custody minor. Total sentence including remission 14 years, 5 months, 8 days.
14 years.
Minor.
Passive is acid. 3 number कोर्ट है
Total sentence including remission.
Pass on that the custody certificate copy ଟା ଦିଅନ୍ତୁ ଆପଣ ରଖିଦେଉଛନ୍ତି କେମିତି ଆପଣ How many murders? Single murder?
Single murder.
376.
76
Conviction court.
High Court of Orissa.
Nine later. With number 6 actually. The convict not only committed upon deceased, who is an old lady of 70 years, but also killed her. Rape and murder. Before we clearing. This plus there is that I have told the religious order. About the trial of the conviction, pleasure Chaudhary, Charles Sat for the Ganchandi, the Garoso, total Michigan and Sri. Give it. The land council for the state has produced the conduct certificate, so also the custody certificate, which is taken on the document.
Submitted, my lord. Next submitted.
Last week today, my scanning in
14/7/25.
record na adele.
I would have did.
Nahi.
Out of the.
The put up this matter after entering puja holiday. Yes.
Item number 19.
May I please, Lord, sir? The petition filed the IF for bail will not say conclusion. The occurrence took place in 3/9/2015. I have given a date for convenience for not 3/9/2015 and charge sheet head under section 302 and 201. Has
Your bail application was never rejected.
never rejected.
And what is the offense here?
302.
302.
302.
How many years you were in custody?
Your lordship, near about 10 years. Last
Occurrence took place in 2015.
Yes, sure.
So
On the date of occurrence.
trial court record আসছে?
Yes, sure, lordship.
Just trial court final form বার করে ଆପଣଙ୍କର ଡେଟ୍ ଅଫ୍ ଫରୱାର୍ଡିଂ ହେଲା 4/9/2015 ତ 10 ବର୍ଷ ପାଖାପାଖି ହେଇଗଲାଣି।
Yes, sure, lordship.
ଆଚ୍ଛା 10 ବର୍ଷ କମ୍ପ୍ଲିଟ୍ ହେବ। ବେଲରେ ଯାଇନଥିଲ ତ?
No, I am on killed his father. Son killed his father. Intoxication moment. And PW5 with the mother is the wife. ମଦ ପିଇବାକୁ ମନା କରିବାରୁ ରାଗିକି by means of cutlery
Now, what is the status of the mother? Because once he goes, he may commit another murder. That's why you have deposed against me.
ସେ ମିଶିକି ରହୁଛନ୍ତି ଛୁଆଟେ ହେଇଛି ତାର ଯେତେବେଳେ occurrence took place.
No, you take the opinion of the mother because there may be life threat also.
Right.
See, on the basis of the evidence of the mother, this man has been found guilty for killing the father. Now, once he goes out on bail to the same house, the first target may be the mother also. So just look in the IN number so and so. This is an application for bail. on the ground, mainly on the ground that the petitioner has remained in judicial custody for 10 years. The contention of the land council, contention of the land council for the petitioner that the petitioner has been found guilty under section 302 and he has been acquitted of 201 or both
No, 302 only.
302 of the Indian Penal Code for killing his father. And the mother of the petitioner, who was examined as PW5, is the sole eyewitness to it.
Yes, sure.
And he may be given some time to obtain instruction about the status of the mother of the petitioner. As in case of release of petitioner, there is likelihood of risk to her life. Put up this matter, give a date. Yes, next. And you also obtain the instruction about the criminal antecedent.
Item 20.
Yeah, please.
fine, that is to be allowed. Yes, next.
Item 21.
21, my lord, no. I pray for time, there is no fine, madam.
Contact?
There is no fine, let me express something.
ଫାଇଲଟା କାଲି ଦେଇନାହାନ୍ତି କେତେ ଗୋଟେ ଫାଇଲ ଦେଇନାହାନ୍ତି
jail criminal appeal, your lordship. 19/6/2025 specific direction was there.
Next week, okay, no. Next,
Item number 22.
as prayed for by the land council to the state.
That is, yes, it's filed for bail, not convicted and
You do one thing, you take all these files in your pen drive, might be missing from your office. ये जो जेल क्रिमिनल अपील गुड़ा तो पुराना अपील वर्तमान आसीची तो नहीं जानते अपन ट्रायल कोर्ट रिकॉर्ड ये सब पेन ड्राइव रे नहीं जानते अब पेपर बुक भी है कि अपन नहीं जानते जहाँ नबा था तो otherwise जानते yes next
convicted under section 302, madam. Convicted under eyewitness, two eyewitness. Earlier, you also called for the
just
custody certificate. and
council
notice
produce the custody certificate as well as
and
the criminal
no
antecedent.
antecedent.
As a status of PW10 is an eyewitness to the occurrence.
I appeal.
कौन से PW10 की है?
Sole eyewitness is doctor of the.
Doctor of one of acting. And related granddaughter.
Just PW10.
10.
Informant is my paternal grandfather, deceased was my grandfather. Accused is my elder father. अच्छा सामान्य ये होची झियोटा होची ये झियारी तार जहाँ को मारला सी है वो जेजे
Four brothers, so one of the
ये three blows by means of tabal has on the head of the deceased as a result of which one.
two eyewitness. No, one eyewitness. The contradictory, last statement he not says, want to know where he has stated.
Wait. Pooja Banya is staying in Raipur. Acha, he has already got married. କେତେ ବର୍ଷ ରହିଲେଣି ଆପଣ?
More about 8 years.
ଫାଇନାଲ ଫର୍ମଟା ଦେଖିବା ଆପଣଙ୍କର ଇଏଟା ହଉଛି 13/11/2017 ଆପଣ ବେଲରେ ଯାଇନଥିଲେ ତ?
କେବେ ଯାଏ?
Total 7 years, 7 months, 11 days. Last date 7. That is shown.
As per the order dated, previous order था देखिए 14/7/2025, the Learning Council for the state has produced the written instruction received from IIC Muri Bahal Police Station dated 24/8/2025, which indicates that PW10 is now married and she is staying at her husband's place. The written instruction is taken on record. Stops. Land counsel for the petitioner submits that the petitioner is in judicial custody since they had for trial court record. Since 13/11/2017. And there is no chance of early hearing of the criminal appeal, jail criminal appeal in the near future. And balance of convenience is in his favor, and therefore the bail application may be favorably considered. Land counsel for the state, on the other hand, opposed the prayer for bail and stated that Peter 15 is the sole eyewitness to the occurrence. And
witness.
Huh?
Two eyewitnesses,
PW ten होगी
informer, wife of deceased.
PW ten and PW four.
PW five and PW ten.
PW five and PW ten are the eyewitnesses to the occurrence, and they have stated that the appellants assaulted the deceased by means of consider tabor, which is corroborated by the evidence of the doctor. कितना बचो?
Dr. Mylord, PW eight.
PW eight. Who has opined the cause of death due to hypovolemic vital organ stop. Considering the submission made by the land council for the respective part in view of the eyewitnesses account of PW five and PW ten, coupled with the evidence of the doctor, PM doctor, bracket legal PW eight, not inclining to release the petitioner on bail on merit, but taking into account the period of detention of the petitioner in judicial custody and absence of any chance of early bail, we are inclined to release the petitioner on bail 3 months, no? Yes, next week. Okay. Thank you.
Item number 23.
My laptop. My laptop bill, IA number 21, 2024. Custody period 6 years, 9 months. The number of
May it please your lords. The appellant has been convicted under section 302-201 and sentenced to
Have you received the copies of the exhibits and all the things?
No, my lord.
Your contact number could not be, have you got the pen drive with you? Because the soft copy of the trial court record is available, that can be given to you.
I will collect.
Because you are to collect it and
Yes.
otherwise it would be difficult to place the bail application and you want entire thing. And paper book has also been prepared.
Yes, ma'am.
Have you received the copy of the
Yes, ma'am.
paper?
I've taken the paper. So,
Then that is all right, you can argue the matter. What is the case?
302-201, my lord.
Yes.
And sentenced to undergo for life. The appellant is in jail custody.
How many years he is in custody?
2 years,
Uh,
right?
Till
Kevin,
today is more than 7 years, 6 months, my lord.
when was he taken to custody?
It was taken to custody on 1/2/2018.
Second page. 1-2 ହେଲେ ଆପଣଙ୍କର 2 ବର୍ଷ କେତେ ମାସ ସରି 7 ବର୍ଷ
6 ମାସ.
7 ବର୍ଷ ହବ 6 ମାସ 7 ବର୍ଷ 6 ମାସ ତ ଆଇ ୱିଟନେସ୍ କଣ ନା
No, my lord, circumstantial evidence. That he was Sean killed his father.
ଆଇ ୱିଟନେସ୍ ତାହେଲେ
No, I have
no eye witness. So on what basis that has been done?
PW4 is the informant matter,
Uh,
brother of the deceased.
oh, acha, you buried the dead body of the deceased inside the house,
Yes, that was
covering the bricks and paddy straw.
Yeah.
Also-
Disentered it.
So, setting fat on the dead body with an intention to cause disappearance.
There was acute smell coming from the house. It's recovered.
That is the suspicious of the PW4 because both the father and son were residing in the same house. The father was leading his life by begging, and the accused appellant was an unemployed man.
How many persons were staying in that particular house?
Two person man.
Son and father.
You and your father. Your father's dead body was found in this condition. So you have to explain, and your conduct is also that it has been taken care of. If you say that your father is missing, then you would have reported the matter. You have not done. Rather, the dead body, all these things
Buried.
were found buried in the very same house where you were residing. And how do you?
Evidence is that there that the father deceased used to move from village to village for begging matter.
କଣ ବେଗିଂ ବେଳେ କଣ ଘଟଣା ହେଇଛି ନା କଣ ଡେଡ୍ ବଡି ମିଳିଲା
ଆଜ୍ଞା
ଆଉ ତାକୁ ଇଏ କରି ତା ଉପରେ ଇଟା ଯୋଡି ହଁ your case is that when you were inquired into, you said that your father had been to a different village. ତେଣୁ ତାପରେ the person's suspicion arose and they asked you to open the lock of the room. And taପରେ you told that that has been lost. Then they entered, some foul smell was coming. By removing the earth and bricks and the straw lying over they found that the dead body was there.
My lord, kindly have a glance to page number 14 of the judgment, my lord. The circumstances highlighted the prosecution, my lord. Accused Navaditya Bag is the son of the deceased, and prior to the occurrence, there was a quarrel in between the accused and the deceased.
Further in process.
There is no evidence to this fact, my lord, because nobody has whispered on a single prosecution witness has whispered regarding the quarrel.
How do you get over these 2, 3, 4, 5? 2, 3, 4, 5 circumstances have been noted down by the judgment, trial court judgment in paragraph 14. Let us say that first circumstance has not been proved, but you are residing together, where the occurrence took place. The deceased was not found in the village. The dead body was found under a pit inside the sport room, buried, and it was a homicidal death. Then you dug the body at the and found it. So all these things are there. So you have an exclusive knowledge that it was your father's body is here inside this room and in this position. And
Regarding the homicidal death, there is no specific opinion of the doctor, my lord. PW 11. He has not specifically opined that the deceased man of homicidal death.
fracture of larynx and trachea, and he has opined it was some features of strangulation. Paragraph 27 ରେ mention ହେଇଛି ଏଇଟା ଆଉ ଆପଣଙ୍କର postmortem report ଦେଖଉଛି that evidence of the medical PW11 postmortem report exhibit 4 revealed that there was fracture of hyoid bone with congestion of larynx and trachea, and these are the evidence he has relied upon: medical officer evidence, postmortem report, opinion report, inquest report, and come to the conclusion that it is a homicidal death, not suicidal.
Both the kidneys are not found. The cause of death from the above finding might be due to manual strangulation or hemorrhage.
Kidney after patient. Next.
Number 25.
Yes, Mrs. Sahoo.
Appellant is convicted on the section 302. He was custody since 8/12/2018 till now.
कितने? 18.
तो 12 और 2018.
So 6 years, some months, 7 years.
10 months.
7 years can be long. 12 December 18. 6 years. So 6 years. 6 years, 8, 10 months or 10 months. September, August, so 8 months or 8, 9 months. So, whom you have killed according to the prosecution case?
The informant's wife has living relationship with the appellant.
So you have killed your wife, that is the allegation. You married, informant married?
Informant married to the deceased. Thereafter, the deceased lived with the appellant.
Okay. And he was having also a daughter.
Informant daughter.
Right. So,
Informant is the Sanjay Loha.
the accused married somebody, that is the informant.
Informant.
Wife of the deceased. He married to the cousin brother of the deceased. Married means well, the staying, living relation. On the relevant date, the cousin brother of that means the husband, the present petition, present accused my lord, he assaulted his wife, my lord, and
Just a minute.
father of the accused, he told to the PW2 that my son killed his wife. And from the Ganji of the accused, bloodstain of group A, which is the blood of the deceased, was detected. That is exhibit 16 and 17.
That's for that.
If you come to the page number 11 of the trial court judgment, that is paragraph number 9, concluding part.
Yes, ma'am. The next.
No. Thus, on a careful study of the paragraph, page number 11 of paragraph 9, the last say observation টা আছে paragraph page number 11 10 on a careful study of evidence পাইলে আচ্ছা ঠিক আছে এটা ঠিক
It is on a careful study of the evidences of the independent witness as described above. It is manifest that no one had seen the accused committing the murder of Punni Lohar in the relevant light. In other words, there is no direct evidence against the accused for committing the murder of the deceased Punni Lohar within the meaning of section 60 of the Indian Evidence Act.
now you come to that what are the circumstantial evidence so that has been discussed from paragraph number 11 onwards and
Page 15 of the paper book.
cause of death is homicidal, so that is there. So there is no dispute about the same.
So far as the existence of circumstantial evidence, it is incumbent on the court to find out if the established circumstances taken cumulatively from a chain so complete that there is no escape from the conclusion that within all human possibility the crime was committed by the accused and none else. In that regard, it is alleged in the FIR that the accused was used to have sporadic quarrel with the deceased. On 6/12/2018, the accused assaulted the deceased Punni Lohar by means of hollow iron pipe, and that one Sukhdev Lohar informed the informant that the accused Vikram Lohar had beaten the deceased Punni Lohar to death by means of steel pipe and bamboo stick. Adverting to the evidence of the informant PW1, it is in his evidence that the deceased Punni Lohar was his first wife. The house of the accused situates near the old house of the informant. The deceased had been staying with the accused 2 to 3 years prior to her death after leaving his house. The occurrence took place 2 years back on 6th December. There was altercation between the accused and the deceased on that day. His mother attempted to subside the...
You come to paragraph number 21. Okay. Paragraph number 21 of the judgment, and that is at page, internal page of the 25. Paragraph 21, it starts with in this case, last line. File.
Last line.
Paragraph 21.
In this case, no.
23.
Paragraph 21.
Yes,
For Korango.
It is settled.
That's
law.
not settled, no?
No.
In this
In
case,
this case, the accused has
Page
so
25 last.
27.
In this case, the accused has miserably failed to prove his contention that he has not killed the deceased Punni Lohar in his house, where he is a sole occupant with the deceased. He has not offered any
Plausible
explanation as to how his wife met with the homicidal death in his house, that is, in the bedroom of his house. This non-explanation on the part of the accused as to the death of deceased Punni Lohar forms another link to the chain of circumstantial evidence described above. There is not any material evidence before this court appearing in the evidence of the prosecution witness, including the investigation officers, that any other person other than the accused might have committed the offense. This is the circumstantial evidence appearing in the evidence of the witness from which conclusion of the guilt of the accused is to be drawn as described in the following paragraphs have been fully established. Those circumstances are conclusive in nature and tendency and consistent with the hypothesis of the guilt of the accused.
There are chain of circumstantial evidence such as residing together of the accused and the deceased, quarrel between the accused and the deceased, utterance of the accused soon after the occurrence, seizure of the wearing apparel of the deceased and the accused having blood stain, seizure of weapon of offense, SFSL report which are complete, do not leave any grounds to answer. So these are the
SFSL report at page 79 of the paper book.
79 of
The paper book.
paper book.
Column number 3 and 4, the weapon of offense, one bamboo stick, one steel pipe. There is no blood.
And having to serial number 9. One faded green color ganji marked as J, blood, human, A.
explanation ଦଉଛି ମୁଁ ମୋ ସ୍ତ୍ରୀକୁ ଧରି କାନ୍ଦୁଥିବି ସେଇଥିପାଇଁ ଇଏ ହେଇଛି ବୋଲି but
That was 46 of the paper book.
But then he has to explain,
That
no?
ମୁଁ ତାର ମନା
Then bottom is
ବାଟେଇକି ଦଉନି ମାନେ ହାତଠୁ ଆରମ୍ଭ କରି ସବୁ ଭାଙ୍ଗି ଦେଇଛି ଯୋଉଟା fracture of left shoulder.
PW8 is the doctor.
Injury report ଟା ଅଛି ପରା page number paragraph number 16 ରେ
Total 16 injuries.
evidence ଟା ଦିଆହେଇଛି.
Total 16 injuries.
16 injury fracture injuries ଅଛି forearm, shoulder,
Left shoulder.
buoys, left scapula, right side back,
buttock.
Rupture of right kidney. पेटू गोइठा मारिଛି.
rupture of right kidney. এটা উঠে রয়েছে। Cause of death was due to also internal hemorrhage and shock due to rupture of internal organs such as right kidney and gallbladder.
Man of the informant, who is the first husband of the deceased, was present just before the occurrence.
ନାଇଁ ଗୋଟେ କଣ କଳି ହେଲା ଗୋଟେ ଦିଟା ଇଏ ଯୋଉ ଟାଇପର ମାରିଛନ୍ତି ତାକୁ ମାନେ 15 injuries and ତାପରେ ଅନ୍ୟାନ୍ୟ circumstance ଅଛି ଆପଣଙ୍କର ବେଡରୁମ୍ ଭିତରୁ ଡେଡ୍ ବଡି ମିଳୁଛି ଆଉ କେହି ନାହାନ୍ତି 2 ଜଣ ଆପଣ ରହିଛନ୍ତି।
Man of the informant's house and the deceased house is the accused house is adjacent to each other. The deceased house, the informant's house and the accused house is adjacent to each other. The deceased is the first wife of the informant and living with the accused appellant. So there is a continuous quarrel in between the appellant and the informant regarding the deceased.
କଣ ହେଲା ତାପରେ?
So the informant himself told that there is a peaceful, the page 49 of the paper book. That they lead a peaceful life.
ଏମିତିଆ ପିସଫୁଲ ଆଉ କଣ ଏଇଭଳିଆ ପିସଫୁଲ 15ଟା ମାଡ ଦେଇକିନି ତା କିଡନୀ ଫିଡନୀ ସବୁ ଫଟେଇ ଦେଇଛନ୍ତି ତାର ମୁଣ୍ଡରୁ ସମୁଣ୍ଡ ଯାଏଁ ପିସଫୁଲ ଏଇ ଟାଇପ ନୁହଁ ଏଇଟା।
A complete chain of, even though there is no eyewitness to the occurrence, my lord, a complete chain of circumstances there.
Yeah.
Number 1, my lord, PW7 state that the deceased and the accused both were living together. Number 1 circumstance. Number 2 circumstance, PW10, he stated that on the relevant date and the relevant time, there was quarrel between the deceased and the accused. Third circumstance,
occurrences after incident of Orissa na kon.
After the incident, my lord, PW2 stated that the father of the deceased reached with the PW2 and stated that my son killed his wife. PW2 stated that. And the doctor, PW8, that happened, my lord, the C report, he has an explanation, but this is the circumstance.
My lord, PW1 and 2, PW first, at first PW1, the
after puja vacation, you have not remained for that period. Yes, next.
Item number 26.
26.
Then, and for the subatom, music. We have a Kulanand Sahu, I am for the first item.
First item argument kono.
First item रे किछि आइए नहीं बेल पे
आइए नहीं है। अच्छा। Next तो
सब item रे आइए अछि।
सब item yeah. Yes sir. Oh, he was on interim bail.
Both were on interim bail.
We asked you to obtain instruction about the conduct.
My lord.
Tonight,
My lord.
is appear
Yes, yes.
now.
My lord, I have
the,
received, my lord.
Appellant number 1, Bindu Bag, the interim bail jaitila.
My lord. Negative report received, my lord.
dated 29/10/2024. Litigation रे ଆମେ ତାଙ୍କୁ ଦେଇଥିଲୁ 3 ମାସ bail. While not inclining, ତେଣୁ ଆପଣଙ୍କୁ କହିଥିଲୁ ଯେ inspector in charge of ପାଇକମାଲ police station ରୁ ଆଣିବେ।
My lord, received.
ନାରୀ
ଲୋକ ବିରୋଧ କରୁଛନ୍ତି। Second page ରେ OIC
Second page.
ପାଇକମାଲ
Unsocial hygiene. She had been gathered social person at her house, conducted illegal activity. Local people are opposed for the crime. Strong ill feeling has developed between the other agency. She will be anticipated illegal activity. Local people strongly oppose her presence at the locality. There is every possibility. Even it on lady tagi.
yes. The lady has a extramarital relationship. Killed his husband.
ତାପରେ ଯାଇକିନି ଏସବୁ ପୁଣି ଆରମ୍ଭ କରିଦେଲେଣି ଏସବୁ।
He has not gone to Paikmar.
The report ତ ଦିଆଯାଇଛି।
ରିପୋର୍ଟ ଆସିଲାଣି ଆଉ ଆପଣ ଯାଇକିନି ଏଇ ଟାଇପ୍ ପୁଣି ଆରମ୍ଭ କରିଦେଲେଣି।
Arambo, there is apparently words. That is not there.
You will give him a report so that he can.
ମୁଁ xerox ଆଉ ଗୋଟେ copy ଅଛି, xerox କରିଦେବି।
Xerox copy ଦେଇ ଦିଅନ୍ତୁ। I will take the Land Council for the state has produced the conduct report on the conduct of the petitioner while on interim bail. This same is taken on record. Let a copy of the same be handed over. You take instruction on put up after puja holidays. अच्छा इधर आठ से आसिव ये जो हाँ along with the first item that JCRLS. We are just coming within 2 minutes.
Item number 27.
Item number 137 of 25 for bail. Case is based on circumstantial evidence. On the previous day, there was a quarrel. And on the next day morning, the dead body was found on the railway track. This doctor is PW12. On examination, he found only one antemortem injury on the head, and others are postmortem injuries. And also find that.
Paragraph number 5 says that it's based on circumstance.
Yes, ma'am. Based on circumstances are that firstly that before the murder of Prabhat Naik on 22/2016, once in the morning and once in the evening at about 9 p.m. and once in the night at about 11:30 p.m. there was quarrel between Prabhat Naik on the one hand and the accused persons on the other. This fact is proved by Panchu Naik, PW2, Prafulla Naik, PW5, Navakishore Pradhan, PW6, Gaurang Naik, PW9, and Gautam Kumar Naik, PW10. Secondly, that Prabhat Naik and his wife, due to some dispute, were residing in a separate house at Kelasahi. And the other accused person also residing in another house near their house. The deceased and his wife, accused Ira, alias Kirati Naik, were alone in the night of 22/23/2016. Hardly that at about 4 a.m. on 23/2016, the accused persons were found absconding from their house. They were arrested by police on 15/2/2016. Fourthly, that Dr. Lakshmikant Behera, PW12, during postmortem examination, found 6 external injuries on the dead body of Prabhat Naik and opined that injury number 4, lacerated injury of size 5 cm into 3 cm, school deep over occipital region, is antemortem in nature, and other injuries are postmortem injury in nature. Injury number 4 might have been caused by hard and blunt trauma, and other injuries would have been caused by railway runover. The death of the deceased was due to craniocerebral injury and its complication, and the time of death of the deceased was within 12 to 24 hours of the time of his postmortem examination. Fifthly, that though the witnesses have stated the accused person were quarreling with the deceased on 22/1/2016,
The 5 persons were facing trial.
4 were acquitted and the only appellant has been convicted.
No, on what basis?
On the basis that he was
Specific material.
Yes, madam. On the basis that paragraph 12 is the finding.
Because there are no eyewitnesses, so. Paragraph 12.
Paragraph 12, that in view of the evidence on record, prosecution proved the following circumstances against the accused persons.
Yeah.
There was dispute for money between accused persons and the deceased, for which there was quarrel on 22/2016 between accused Vijay Naik and deceased Prabhat Naik, and as such, accused Vijay Naik had a motive to eliminate deceased Prabhat Naik. The accused persons and the deceased were not in good terms, and as such, the deceased was residing separately in another house from the accused persons about 2 months prior to the occurrence. Third, there was a quarrel between accused Vijay Naik and deceased Prabhat Naik in presence of other accused persons on 22/1/2016, once in the morning, thereafter at about 9 p.m. and lastly 11:30 p.m. The deceased was found dead at about 4 a.m. on the railway track after about 4.5 hours of the quarrel. The deceased Prabhat Naik died a homicidal death and was thrown on the train line to give a color of suicidal or accidental death. In the morning at about 4 a.m. on 23/2016, the accused persons were found absconding from their house and were apprehended on 15/2/2016 from their village. And in the statement recorded 313 CRPC, the accused persons took a false plea that they went to their village 2 days prior to the occurrence.
So only distinguishing feature is you ଯେତିକ ତାହେଲେ ସେ ଯୋଉ କେବଳ ଯୋଉ quarrel ଟା ଅଛି ତା ଛଡା ତା ବାକି ସବୁ ସମାନ।
Yes, ସବୁ ସମାନ।
ସେ ଯୋଉ quarrel ଟା ହେଇଥିଲା
Specifically, there was quarrel between the Vijay and the deceased.
ସେଠିକି ତ
Yes.
ସେଇଟା ଦିଥର ଦେଇଛନ୍ତି, ଗୋଟେ ହେଲା 9ଟା ବେଳେ ହେଇଥିଲା ଆଉ ଗୋଟେ 11:30 ରେ
11:30 ରେ ହେଇଥିଲା।
Once in the morning, then 9 p.m., then
11 p.m.
3.
ତିନିଟା ବେଳେ ହେଇଛି ତାର ଭୋର ମରିଛି 4ଟା ଇଏରେ।
Specifically, PW6 stated that the present appellant assaulted. PW6 କହୁଛି
eyewitness ନାହାନ୍ତି ପରା।
ନା assault ଯୋଉ 9:30 ରେ ଯୋଉ ଗଣ୍ଡଗୋଳ ହେଇଥିଲା,
9ଟା 30 ଯେତେବେଳେ ଗଣ୍ଡ P6 ମାଇଲଡ ଆମେ 9ଟା 30 ରେ ଯୋଉ ଗଣ୍ଡଳ ହେଇଥିଲା ସେତେବେଳେ ସେ କହୁଛି ଯେ ବିଜୟ ନାୟକ ଆକୁ ଡିସିଷ୍ଟ କି assault କଲା ତାପରେ P6 also stating that there was a mark of dragging from the house of the accused
No,
to
no,
the railway.
please come to P6.
Madam.
I know all the accused persons of this case. They belong to our side. I know the deceased Bapi Prabhat Naik. I know the informant Gautam Naik. The occurrence took place in the night of 22/23/2016 at Kella Sahi Basti. On 22/23/2016 in the morning, there was quarrel between deceased Bapi Prabhat Naik and accused Vijay Naik. Vijay Naik is the brother-in-law Sodu of the deceased, being the husband of sister of the wife of Prabhat Naik. I, along with Prafulla Pradhan, told them not to quarrel and separated them. At about 9 p.m. on that day, I found deceased Prabhat Naik and accused Vijay Naik were quarreling. Accused persons Sara Naik, Kirati Naik, mother-in-law of deceased Prabhat Naik and wife of Vijay Naik were present at the spot. At that time, accused Vijay Naik was pushing deceased Prabhat Naik. I, along with Prafulla Pradhan, P5, went to the spot and separated them. Thereafter, we went to our house and slept. In the morning, we found the deceased lying on the train line being dead.
ତାପରେ
I went there and found the deceased lying dead facing downward.
and a chuni was tied around his neck. The train line is near to our boss.
Act of dragging on the ground from the house of the deceased to the train line.
Train line where the deceased was laying.
P5 coaches, the deceased was a criminal having a lot of criminal cases in which background a lot of people were trying to kill him. Doctor Kojan, jo injury number 4, doctor P12.
Sorry, P12.
Se Kojan, jo injury number IV ta only one injury is antimortem.
Skull.
And that can be caused by dash to the train also.
No.
Opinion paragraph 2 re injury number IV will not cause instantaneous death. Injury number IV is possible on dash by a train.
Injury number 4 is the antemortem in nature.
What injury antemortem in nature?
That is injury number 4.
Postmortem.
ଯଦି ସେଟା ଆଣ୍ଟିମର୍ଟମ ତାହେଲେ ଆଉ ରେଲୱେ ଟ୍ରାକରେ ଆଉ
ସେଟା କହୁଛନ୍ତି ହେଇପାରେ ବୋଧେ।
ଏମିତି କିଛି ବିଶେଷ ଡିଫରେନ୍ସ ନାହିଁ ଆପଣଙ୍କର ଯୋଉମାନଙ୍କୁ ଆକ୍ୟୁଟାଲ କଲା ଆଉ ଏମାନେ ଖାଲି ଏକ୍ସେପ୍ଟ ଦ୍ୟାଟ ତାଙ୍କ ଭିତରେ ପୁsh and pull ହେଇଥିଲା ରାତି କେତେଟା ବେଳେ 9ଟା ବେଳେ ନା
9:30
they being the member of the family
they were present.
they were standing
They are present and just after the occurrence all fled away.
ହଁ ତାପରେ
Therefore suspicion arose against all the accused
suspicion basis
against all the accused person. But trial court, since there is specific allegation, the quarrel and assault counter assault between the accused and the deceased, trial court convicted the present appellant and the acquitted other accused persons.
କେତେ ବର୍ଷ ରହିଲାଣି
15/2/2016
Are the Learning Council for the petition, Learning Council for the state. The Learning Council for the petitioner submit that the petitioner is in judicial custody since 15/2/2016. The petitioner, along with 4 other family members, faced trial for commission of offences under section 302(201)(34) of the Indian Penal Code. And it's a case based on circumstantial evidence. And the Learning Trial Court, while acquitting the co-accused persons of all the charges, found the appellant petitioner guilty under section 302(201) of the Indian Penal Code. And the only distinctive features between the petitioner and the co-accused persons who were acquitted is that the petitioner quarreled with the deceased on 22/11/2016 at about 9 p.m. And there was some push and pull between them. The land council further submits that the doctor has has opined that the cause of death was on account of craniocerebral injury and its complication. And injury number 4 is a lacerated wound, which was over the occipital area, and the doctor has stated that such injury is possible by a train. And the dead body of the deceased was lying on the railway track, no? Railway track. Further submits that in view of the available materials on record, there are good chances of success in the appeal, and balance of convenience is in favor of the petitioner.
मतलब 9 years नहीं से कितने बेल थिला the accused was on bail ಇಲ್ಲ ಬೆಲ್ಲ custody form security form টা আছে না
just a minute, let us see.
I have to obtain the document
please ওই জানা পড়বে এই ট্রায়াল কোর্ট অর্ডার শিটটা দেখি
জেল ক্রিমিনাল অফিস
बेलबन security ଅଛି
just a minute. Someone gave it like TPR produced with application all the 5 UTs are produced. 5 UTPs are produced. UTPs are not produced. UTPs are produced. या ना कौन
विजय नायक
विजय नायक प्रस्तुत अच्छी 2017 अच्छी प्रस्तुत. No, Mr. Nayak, you see, the judgment was pronounced on 31/3/2018. We are seeing the order sheet. And on the previous date also, Vijay Nayak was a UTP. That is order dated 29/3/2018 to 31/3/2018. लिखा है ना यूटीपी विजय नायक was produced from custody. अब 31/3 ने judgment हला तो it's not good. लिखो. Okay. Land counsel for the state oppose the prayer for bail and place the evidence of अपन कहाँ से जो evidence टा place कोटे जो कदिया है P6 I would place कले बोले PM doctor that is PW 12 no PW 12 considering the submission made by the land council for the respective party, absence of any direct evidence, nature of circumstantial evidence on record, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail. Yes.
Item number 28.
May I please, your lordship? My lord, here is a case. The entire case is based on circumstantial evidence. No eyewitnesses to the occurrence.
Just a minute. We want to see the previous order. That is order dated 28/7/25. ଆଉ ଗୋଟେ କେସ୍ ଆପଣ ନାଁରେ 307 ଆଉ ଅନ୍ୟ ଅଫେନ୍ସ ରେ ଆପଣ ଟ୍ରାଏଲ କେସ୍ କରୁଥିଲେ.
He has been convicted in that case.
କନଭିକ୍ସନ ଅପିଲ ରେ ତାର ସେ ଯୋଉ 307 ଟା ସେଟା ସାଇଡ ହେଇଗଲା ବଟ୍ ଅନ୍ୟ ଅଫେନ୍ସ ଗୁଡା ରହିଲା. ଏଇଟା ସେଇଥିପାଇଁ ସେ ଇନଷ୍ଟ୍ରକ୍ସନ ନେବାକୁ ଚାହୁଁଥିଲେ रिविजन करिया फाइल करछन कि नहीं कोन है कोन आपण कोन इंस्ट्रक्शन कोन अपील टा आपण डिस्पोज ऑफ होईची 2/12/2014 रे क्रिमिनल अपील रे 307 charge set aside offenses under 323 341 506 363 that was confirmed. So what is your reply?
Regarding this, I have not taken any instruction from the appellant. Yes, jail appeal.
So no, that was the test when we sought for the criminal antecedent. This has been brought to our. You get it that what is how many years you are in custody?
Custody since 13/12/2017, more than 7 years, my lord, in custody.
Direct evidence achieved.
No circumstantial evidence, that too extrajudicial confession before the IO inside that police station.
Last in theory.
No,
Last in theory recovery of weapon.
no, that's in theory, that is PW18, is turned hostile. There are 21 numbers of prosecution witnesses. Out of 21, 9 persons turned hostile. That is very material witnesses, including PW2, Indranath Pradhan, husband of the deceased, and brother of the deceased, PW13, Vivekananda Malik, and PW14, Bundu Malik, father of the deceased.
No,
I'll place PW7.
Huh?
I'll place PW7 for a minute.
PW7.
7.
On file last year.
PW7. Paragraph 2, you know. At about 12 midnight and 19/12/2017, I went to attend call of nature to our village school field. Chandravati Pradhan also went with me to attend call of nature in that.
Chandravati ki hai?
Another person.
Chandravati PW18.
All right.
While returning,
8, sorry. 8.
while returning, both of us took note that Jean Dad Amritlal, who is the accused here, was coming from the house of side of the Hasina towards his house with a hammer in his hand beside their well. At evening hours of 19/12/2017, I found Hasina Amritlal, wife and sister of Amritlal, and Susama were sitting.
Hasina was deceased.
Hasina is deceased. Were
No,
sitting.
note of the CA Kongla Asutila.
Hammer Nikita
ଘର ଆଡୁ ଆସୁଥିଲା
ଆମର ଧରିକି ଫେରୁ
ଆମର ଧରି ଫେରୁଥିଲା ହଁ
At
ତାପରେ
a midnight range.
ହଁ ବୁଝିଲି
Paragraph 3 is the last set.
at
When
the
this-
evening hours
At the evening hour, they were sitting beside the fire in front of the house of the Hasina.
ହଁ
Paragraph 7, your lordship. I found Amritlal was passing a well in that night. That well at the Bari side of Hasina. I did not see Amritlal was entering the that night.
My lord,
So,
so many-
can we see paragraph PW9 for a minute? PW9, paragraph 3 and 4. That says that reflects the motive on the part of the accused. Paragraph 3, Amritlal made some sexual advance with the deceased. This is refused such advance of the accused. Accused caused death of the Hasina for that reason. Amritlal committed the murder of Hasina. Then he poured kerosene on her and lit fire.
ये क्यों नहीं अल्लाह what is the source of his knowledge
If, the source of knowledge has
बाबा
not
आपको कोई direct evidence नहीं committed the murder of
it's
Hasina
there
Poor
is
hero
direct evidence.
हाँ किया था
Rishabh, thereafter, PW10, paragraph 2 years. PW10, paragraph 2 years. Paragraph 2 years. It is a fact that I was in jail in connection with murder of Swansu. So that is not a fact and answer.
This witness actually he was examined to depose about the last scene.
Last scene.
PW10.
PW10 is turned hostile. It is
PW2
said
is
that
the
during
husband.
his stay Amritlal disclosed
Oh, the extrajudicial confession. Extrajudicial confession
that he was in love with Hasina
He hospital. He
ये
come.
करिएगा
and after
resign कला
and
PW2
Amritlal
is the
proposed
husband
this
of the
act.
deceased.
husband turned
PW2 is the husband of the deceased. Your Worship. Paragraph 3 would be relevant.
Who is the doctor?
Doctor, my lord, PW
3. Dr. Rabindranath Sahu, PW3.
hammer could मिळला ना asini.
No,
As
no.
in PW
One not-
1617, which is section 27 witness.
Hammer not produced before the court that IO stated.
MO1 which is Hathud.
IO stated in cross-examination.
Description objective लिखे MO1 is the Hathud.
Producing नहीं कौन.
IO stated in cross-examination, my lord, IO is PW21. May
Exhibit है MO mark है.
Judgment में MO marking ना. Because of
I made prayer MOCSC for postmortem 11 is
PW 16 and 17 are the witness to the section 27 recovery at the instance of the SPC.
So if extrajudicial confession is taken away because PW 10 has not supported the prosecution case. So the evidence remains that the witness PW 7 has seen this accused coming from the side of the deceased with a hammer.
She saw them sitting in the evening together. Then she saw that he was coming from the side of the deceased house in the midnight along with a hammer.
Yes.
Yes.
Coupled
My
with
lord.
section 27 recovery.
My lord, incident took place in winter's time. That on the evening night, accused and deceased and
They were
accused
sitting together.
all together sitting and basking fire. Thereafter, then all went away to their respective home.
That is not
PW7
there.
and 8, that is there. PW7 and 8, they both around 12 p.m. saw the accused coming side that deceased house.
coming from the house of
By
Kasila.
side of the house
Got
with
it.
a hammer. That is little distance from house that place it is distance. How they PW8 turned hostile. PW7 only stated about with a hatuda they coming from little distance and it is night time. And no one seen that accused entered to the house to commit this crime.
What about the track record of this man?
He has already been convicted in another case.
No, that is one case is there, but 307 acquitted, he has also not obtained instruction. Only one case, no?
Yes.
And accused with a married person and having 2 child also.
No, that's
PW, who is the husband of the deceased, who states that the motive of the
So this PW7 evidence,
Yes,
how do you overcome it?
My lord,
PW7 when he states that Amrutal was coming from the house side of Hasina
side only.
towards
And no
his
one
house with a
stated,
hammer.
not a single witness stated that appellant entered to the house to commit this crime or anything suspicion thing, because they all together sitting in a basking fire and in night time only when they
Where from that hammer was recovered?
from the, you should kindly see PW 16 for him.
IO.
No.
No, 16 is the witness to the section 27.
Oh, leading to this case.
Yes, sir. Paragraph number 4 of that PW 16. May I please? IAC Sethi Babu, Jidagiri PS has called so-and-so and myself to the PS, where Amritlal and I were present. The accused confesses guilt in my presence that he killed deceased by means of a hathudi blow and kept the hathudi and his wearing apparel before the date tree near the playground of a Panganaju. I, along with the IAC Sethi, I proceeded to the spot. Accused brought the concealed weapon of offense, hathudi, and wearing apparels near the date tree and produced before the IAC Sethi. My brothers.
one more thing, my lord. Whether that
MO1 is the said hathudi and MO2 is the black colored jeans which is recovered. That paragraph.
but here is a case, there is no chemical examination report. So whether that hatuda is used by the appellant, whether any fingerprint is there, that report is not furnished by that prosecution. Here it is in IO already stated in cross-examination all these things. There are permits I will submit. In cross-examination it is clear everything.
C report has not been obtained,
not been obtained.
but it was forwarded. See,
Forward-
forwarding report of the exhibits which exhibit 15 or
So it is stated
but it
by
was not produced.
not produced before the court.
କାରଣ ପ୍ରେୟାର
Material object-
JMFCଙ୍କର ପ୍ରେୟାର ବି ଅଛି exhibit 14 ଆଉ forwarding report of the exhibits ହଉଛି
That
exhibit
material
15.
object and C report is not furnished by the.
No, it's all right with this.
Was sent on 18/1/2008. How was it? The report is not.
Report admittedly you are you have not produced and also perhaps you have not also produced that weapon before the doctor who
Doctor, that also is there.
conducted the PM
Doctor who
who
conducted
sought for his opinion regarding
that.
possibility of the injury by that Hathudi. এটা ମଧ୍ୟ କାହିଁ ତା evidence ରେ ନାହିଁ ତ
That is not there.
କେତେ ବର୍ଷ ହେଲାଣି ଆପଣଙ୍କର?
My lord, I am custody since 13/12/2017. Now it is more than 7 years, maybe 7 years, 7 months, my lord.
Rishabh, I was placing the PW9, paragraph 3 regarding 3 and 4 regarding the motive. Yes, sir.
Sister kille.
Yes, sir.
It PW7.
PW2 is the husband. May I place the paragraph 3 for a minute? Accused, third line from the top list. Accused Amritlal and my wife were basking for son next day morning. And after some time, my villagers informed me again regarding the Amritlal committed murder of the hammer. PW2 year. Yes, sir. Paragraph 3 and 4 year. 4 states about the motive. It is a fact that I gave statement to the police on my arrival at our village. I heard the accused kept devil eye on my wife and committed her murder by assaulting her with a hammer. And PW9 also states about the motive of the accused. In paragraph 3, PW9.
Was working in Tamil Nadu. He was not there. The husband is turned hostile.
Yes, sir.
Deceased to be present. Deceased sister of the. ରାତି 12ଟାରେ 12ଟାରେ ତାଙ୍କ ଘର ବାଡି My lord, Doctor PW3.
Multiple injuries. Multiple injuries. Paragraph 2 says
dead body inside that house, my lord, lying.
paragraph 6. Paragraph 6 says that all the burn injuries are post-mortem in nature. Post-mortem in nature. The injuries are ante-mortem in nature and the burns are post-mortem in nature. In para 7, they said the cause of death is head injuries. Yes. Next. 313 statement is complete denial. No explanation has been given.
And in FIR, that PW 11 stated, someone killed my
Paragraph-
sister-in-law.
Paragraph 11.
ତେଣୁ ଯୁବୃତ ଏ କାଣ୍ଡଟି ଘଟିଥାଇପାରେ ବୋଲି ଆମେ ସନ୍ଦେହ କରୁଛୁ PW 11. And PW
Kindly
11
see-
got information from PW 6. PW 6 has no direct knowledge.
Deceased ର ଘରେ
Deceased ର ଘରେ
she was alone.
ଏମାନେ ତ ବସି ସନ୍ଧ୍ୟାବେଳେ ନିଆଁ ପିଇଲେ ତାପରେ ଡିସିଜ୍ ର ଘରେ କେମିତି ହେଲା ଇଏ ତ ତା ସ୍ୱାମୀ ସାଙ୍ଗରେ
Mother in Hiroshima, kindly see PW 11 paragraph 2 for a moment. Let's just place that paragraph. During those days, I was at G Udayagiri at about 6:30 a.m. of 27/2017. One of my co-villager Lakshma Sahu informed me over phone that the half-burnt dead body of Hasina was lying at her house. I immediately left for our village and arrived at our village. I went to the house of Hasina. I found the dead body of Hasina was lying at her kitchen and in half-burnt condition. I found blood stains at the outer side of her house. Some drag marks were also visible on the ground. Immediately, I gathered impression that it is a case of murder. Hasina was staying alone in that house. My mother-in-law, who was staying with Hasina, was absent on that day as she went to visit her daughter's house. Her husband was working as a delegate. The time of murder, the deceased was alone at her house.
you do one thing, you just obtain that instruction, or you take it after vacation about that case, what happened to the conviction, which was set aside by 307, and that instruction you are not having that. It's a jail criminal appeal, so you have been engaged as amicus curiae.
My lord.
So why don't you opt on instruction? He may be facing difficulty. When we put a pertinent question to when we made a query to the London Council for London amicus curiae as to what happened after the appeal referred by the appellant was disposed of in criminal appeal number 21 of 2023 by judgment and order dated 2/12/2014, in which his conviction under section 307 IPC was set aside. However, his conviction under section 323, 341, 506 by 363 of IPC was confirmed. The London Council London Council submit that he has no instruction. However, let the London Council for the state obtain instruction as to whether the appellant preferred any appeal against the order of the London Appellate Court, and if so, what is the result of the revision? That instruction will get put up after puja holidays.
Published.
Item number 29.
Item number 29, the lordship has called for a report regarding custody, criminal antecedent, and health condition of the convicted. That will be some more time.
Next week.
Yes.
Item 30 का
29.
29.
and 30 minutes. And 29 is
See, a matter.
नहीं आ गुटिया.
They're different.
29 ରେ ଡକାଇଛି 29 ରେ ଲେଖନ୍ତୁ land council for the state seeks some further time to obtain ଏଇଗୁଡାକ ଯୋଉଟା ଲେଖା ହେଇଛି ତ next week କରିଦେବି keeping it next week
Yes, sir.
yes next 30
Item 30,
30 ର କଣ ଥିଲା order ଟା previous order
Last time that I received the paper too.
Well, there is an application for
Bail.
stay of realization of fine as well as bail.
Yes, sir.
So what period you have remained in custody?
That's
First is in 2020.
20.
As per his application.
13/10/2020.
302 case.
30. Eyewitnesses are there.
Eyewitnesses there.
Yes, sir.
Who are the eyewitnesses?
6, 7, and 2.
6,
2, 6, and 7.
6 and 7. Who is the doctor? PM.
PW 5.
Let me kindly give me 1 minute time and let me prepare the justice. I have not gone to the.
Asha, you know. Mr. Naik, Learning Council, appearing for the appellant, submits that he has received the paper and he may be given some time to prepare this case to argue this case so far as bail is concerned of this matter. Next.
item 31,
31. The notice, the paper book has been prepared. A copy may be there.
Paper book upon neither. No, nothing. Mr. Sanjeev Kumar Das, Land Council for the appellant is present. The Land Council for the appellant, so also the Land Council for the state submit that paper books have been prepared, but they have not yet received the same. Let the copy of the paper book be supplied to the Land Council for the respective parties. Put this matter to date the event. Next.
item 32,
Mr. Panda, there
Wait,
was.
please, my lord. I'm
Yeah.
appearing virtually minutes. On behalf of Mr. Panda, I pray for a Passover, my lord.
Next, 33,
Oh, bless you.
item 33,
Ms. Pratyusha Naidu.
On behalf of Mr. Procedural Naidu,
I just now served a copy of the reply to the comprehensive.
She requested me just to take an adjournment. She is filing the affidavit of.
He has to obtain instruction on
criminal
that.
entity.
The Learning Council for the. You have filed for the court.
Yes.
Standing. You file it in the counter so that it will be scanned and counted. Don't file here. The Learning Council for the appellant has filed the comprehensive affidavit relating to the criminal antecedent against the petitioner, serving copy on the Land Council for the state. Now, submit that he will file for them. He will file the comprehensive affidavit today. So and so, and copy has been served on the Land Council for the state. Who takes some time to obtain instruction on the comprehensive affidavit. Matter will be listed on such answers. 50 file for them, the scanning ignorance.
oh, bless you.
Yes.
item 34,
Your lawsuit. The landed court will have a contract of petition. Figure 2 for library section. The petition has been posted since 14/8/2021.
14/8/21,
21 from the
that's
date.
from the date of occurrence itself.
My last.
21 like it's in
कौन अच्छी evidence कौन अच्छी?
3 eyewitnesses also. PW2 is the injured eyewitness Thereafter, PW 5 and 6.
What the injured eye witness stated?
It is this.
Supported the prosecution case?
Yes.
What is the weapon of offense?
It is X, my lord.
X-ray.
Blunt side of the axis.
And who is the doctor?
My lord, the doctor, that is put witness number 1, 2, and 3, my lord.
Doctor kitna? 1, 2, and 3.
PW 8 your lordship.
PW, that is Dr.
8:80 PM doctor, PW 7 who examined the injury.
Dr.
I'll place the
Lacerated wound.
the multiple
Thora injury. Notice so dissection found.
The client is suffering from psychoaffective disorder, my lord. That has not been considered by the court.
the court witnesses have been examined by the court below. PW 1 to 3 your lordship. They have stated that the accused is in a fit condition of mind to understand what he has done and understand the question put to him. Thereafter, he has been convicted.
Not properly assessed because, my lord, the learned court will have categorically stated, my lord, that there is no evidence with regard to the date of occurrence, my lord. But the doctor, 3 doctors were examining the appellant categorically stated that he is suffering from schizoaffective disorder, my lord. That is also to the up to violent. In page 114, the opinion of the doctor.
ନିଜ ତ ସବୁ ଗୁଡାକ ମିଛ ମିଛ କହିଛନ୍ତି ଆଉ କହୁଛନ୍ତି ମିଛରେ କେସ୍ ହେଇଛି false implication. Where is your plea that you are of unsound mind and that was at the time when this occurrence took place you are unable to, what is the material to that effect? କିଏ କହିଛି ଆପଣ ଯୋଉ plea ନଉଛନ୍ତି?
My lord,
unsoundness of mind
after framing of charges, my lord, when the case record was posted on 2/5/2022 for recording of evidence, the London SDS filed a petition under section 329(1) of CRPC supporting by medical prescription alleging issue in favor of the accused. That is there, my lord.
So what happened thereafter?
Thereafter, my lord, these doctors has been examined the appellant and they give their depiction. Page 113, my lord. The HOD, Dr. Shankar Sith.
During trial, you examined some witnesses.
Court
From
has
your
examined
side.
some witnesses.
Court.
Court has examined your lordship. CW 1, 2, 3. All are doctors, your lordship. They supported that.
What do they say?
This is, my lord, after going through clinical psychometric assessment report and on personally examine the accused, I opine that he is suffering from schizoaffective disorder. This is the clinical psychometric assessment report of the accused, marked as Exhibit C1 and C2. C1. This is the original letter addressed to the court, where I opine that the accused is suffering from schizoaffective disorder. In schizoaffective disorder, the patient will be having symptoms of schizophrenia at the time, will be having mood swings, frequent change of mood, my lords. The common symptoms of the patient suffering from schizophrenia will be suspicious, aggressive, and violent behavior. At times, hallucination and abnormal behavior. Patients suffering from the schizoaffective disorder can be stayed in family and led normal life. But they have family support and remind.
When these doctors examine the appellant, when these doctors who were examined as court witnesses, they examined the appellant.
Kindly see CW 1, page 113, paragraph 4.
CW.
Who are they?
That's the doctor's initial. CW 1 is the HOD of the Department of Psychiatry, BRM NCH Patipata. The witness on referring to C1 state that the accused was examined for the first time at the hospital on 6/6/2022.
Just a minute, we are not getting it.
Page 114 of the paper.
Paper book paper book here and paper book
Paragraph 4, your lordship. At this, the witness on referring to C1 states that the accused was examined for the first time at the hospital on 6/6/2022. At the time of his examination, he was talking excessively and irrelevantly. He was complaining of sleeplessness. However, during examination report would be established that with him and he was answering the question put to him. At that time, he was having delusions of reference, thinking that the other people are discussing about him. At that time, he was having poor judgment capacity. Again, on 2/11/2022, when he was examined, I was noticed that he is having some delusion of percussion and grandeur. After his examination, he was advised some medication. At the time of examination, he was responding to the questions put to him and was answering logically, but he was aggressive and was talking excessively. In both the times during his medical examination, he was responding to the questions put to him and was answering it. No previous history of his mental illness was presented before me. The accused requires to be under constant medication.
How do you say that at the time of occurrence, that is the relevant factor, not that after this occurrence took place in 2021, August 2021.
There is
And
no
this doctor examined after केबे एग्जामिन कला 2/11/2022
first time on 6/6
रे
2022.
हाँ आज
First the charge was
And 22. So, was he under medication prior to the incident?
That is not produced before the
Witness has been stated that because the doctor suggested that that type of patient need the family support. But in previous occasion, my lord, the wife has left the husband. I mean the
कौन सी
president.
विटनेस कही छे दिए गां रे एंती बुलाबुली करे पागलांग भलिया हुए हमको समके एंती किछ कही छे
Cross examination, my lord.
Number 562 deny on the specific question that he was having some abnormality before it.
No, your lordship kindly have a glance at page 272, para 10, my lord. The accused is related to the deceased as nephew by village courtesy. Prior to the occurrence, our family was in visiting terms to the accused, house of the accused. The accused and our family belongs to one gotra. On the date of occurrence, the wife of the accused was not present in the village. As because, my lord, due to its abnormal behavior, I cannot say if the accused used to talk to him and also used to abuse called in the village on his own. 6 months prior to the occurrence, I had returned back to the village. I cannot say if the accused had assaulted his wife, for which there was a meeting in the village. I cannot say if the accused was treated for his mental illness prior to occurrence by the wife at Ranchi. But here is the question is that, my lord, that particular, that lady, the wife of the appellant has not been examined.
Question may kindly see
the burden lies on you, and you are to, and that is also to be proved that at that particular point of time, it's not that suppose 2 years after some problem arose, there was some kind of, because it may be that on account of detention in jail, those things might have occurred, depression, all these anxieties. So that is not a factor to be considered. The court is to consider whether at that particular point of time, your state of mind was such that you are unable to know the consequence of the act. So there is nothing, rather the witnesses have been given suggestion, they have stated denied that it's not a fact that the accused is suffering from mental illness.
kindly see PW for a minute.
Soon after the occurrence, since April 2000, I am working as program officer, DHS hospital.
Have you
Panipat.
obtained about his present health status? Let us say,
Not at all.
get it, let us see that.
Physical as well as mental.
Get it, let us. The learned counsel for the petitioner during course of hearing of the bail application mainly stressed on that the accused was not, he was unsound of mind, and the court has examined 3 doctors which should show that the mental condition of the accused was not good. However, the learned counsel for the state submitted that in the evidence on record, there is nothing that at the relevant point of time when the occurrence took place, the petitioner was on soundness of mind to know the consequence of his act. However, she seeks some time to obtain instruction about the present health condition of the petitioner. Put up this matter, give an adjournment. We are taking the rest of the matter after lunch.
I made a problem. I made a problem. So after item 18, item 18 thila your lordship, no? I had requested Miss Bina Pani Tripathi to pass over that matter. Your Lordship.
Some instruction we have got also. That is how it has gone
I
from.
pray for next week, your lordship.
So, we come with next.
Item number 35.
From 35 last packaging, your lordship called for some instruction from London State Council regarding my conduct inside the jail. In fact, in the date of incident, I was in custody, except 1 month, which was granted by your lordship. And after compliance of that order, we are surrendered. But your lordship wanted to know regarding my conduct inside the jail during
Not
that.
inside the jail. Why?
Regarding
During your
the
bail.
interim bail as well as the custody bail.
Oh.
No adverse report regarding the interim bail.
You were granted interim bail by order dated 17/1/25. Previously involved in this case means this particular case or some other case?
Pardon?
ये जो लिखिଛନ୍ତି ଆପଣ କେଉଁଝର ଟାଉନ୍ ଜଜମେଣ୍ଟ ଦେଖିଲେ?
He is involved in
ଏଇ
town.
କେସଟା ତ ଦେଇଛନ୍ତି କଣ? 37.
37 is
37,
19.
2019 is the relevant case, which is before your lordship.
Oh, this is 20.
This is 20.
Oh,
This is a
subsequent.
different case,
Another case.
but the offense
But
is
the
same.
offense are same and
Is it a mistake or?
might be a mistake, your lordship. Might
ମାନେ ସେ ତ ସେବେଠୁ ଭିତରେ ଅଛି।
first again 2019 PS case might be I'll clarify.
Because except 2019,
Yes, sir.
other things are
No,
same.
no, on the back side it is written, oh, this is from this side. This is from this side, the letter, 37 of 19, but he has given a reference of 20.
This is
Wrong, maybe.
37 of 20 and the sections are also same.
Because FIR number, of course, FIR number is
Same.
2020?
हाँ से FIR number टा होगी 33 ठीक है।
No, 80,
The present case arising out of which the jail criminal appeal has been
how
filed.
can it be the date on which sentence passed, 6 to 19? Judgment.
Judgment
18th April 2024. Yes,
That might be a mistake.
no, sir.
37 or
Date
20.
on which sentence passed, 6/2/19. ଏଇଟା ପୁରା ଅଲଗା ଗୋଟେ ନା କାହାର?
ये जो date of माने sentence pass होची ସେ ହବା କଥା ମାନେ date of first remand जोटा है
ସେଇଟା
ସେଇଟା କଣ ସବୁ ଏମିତି ଲେଖୁଛନ୍ତି?
The judgment shows he was never released.
No, that's
No,
all
that-
right, but what sort of this instruction has come?
ତାମାନେ ନାଇଁ, we are not very sure whether authenticity of the report.
You have to obtain a fresh report.
FIR, even FIR number
No,
is
friend,
not
that is
correct.
different.
FIR actually,
They have written 2020. 20.
FIR होची 2019 ର FIR.
ଏଇ ଲେଖୁଛି 20
19,
ର.
37 of
So
2019.
this cannot be the report of the person.
I'll obtain a corrected report.
Date of appeal केवे देखेंगे?
Date of judgment
No, date of judgment is 24.
20.
Date of appeal?
Jail criminal appeal.
हाँ.
I have been assigned with
as an amicus team.
and this FIR number
Hmm.
20 will be
No, no,
80
नहीं,
of 20.
अबे it's a printed one, ना? हमने maintain नहीं की. It's a wrong maintain.
But for you also fresh one.
Hmm.
Bring one fresh one, no?
Yes.
for the Land and Council for the state has produced the conduct report. Also the custody certificate of the petition. But on perusal of the same, it appears that the town PS case number is something different than the present case. Similarly, the FIR number which is mentioned in the custody certificate, so also the date on which the sentence passed is not relatable to this case. However, the Land and Council for the appellant submits that the appellant was taken into judicial custody on connection with this case on 6/2/2019, which would be evident from the final form, and thereafter he has never been released on bail. In view of such submission made by the Land and Council for the appellant, the Land and Council for the state seeks some time to obtain a fresh report. So also the fresh custody certificate, huh? Out of this matter and give another date.
Wait for next week. The mother is seriously
It may not be possible.
Next week.
Next week.
Yes.
Next week.
grateful.
Item number 36, we have already received the paperwork that has not been attached to my file. Can I pray for day after tomorrow?
Next week or?
Yes.
Yes.
Item 37.
Council for the state. 37.
Successive bail application, my lord.
What happened to the earlier one?
Earlier one was rejected, my lord.
On what date?
22/10/2024.
22/10.
This is with matter, my lord. CRLA 502 of 2020.
Oh, sure. 502. So rejected, what is the, why we should entertain it within, even 1 year has not passed?
My lord, because the entire evidence has not been discussed.
How much? The
Only
bail order-
basing upon the PW9 statement, my lord.
Bail order has been passed, 8 pages bail order that has been passed.
My lord, only basing upon the evidence of PW8.
Sorry, put up application. Next.
My lord, I am for the first item 100/24. In that item, I filed one IF for bail. That is 143/25. And my
These
lord.
all there is, but these both will come after vacation. Next.
Item 38.
Yes, for bail, I'm under section
The paperwork has been prepared in the meeting.
Yeah.
The
You
copy
have
may
not
be-
received. Have you received the paper book?
No, my.
Receive it. The Miss Dinapani Tripathi. So also the learned counsel for the afferent, so also the learned counsel for the state. Acha, ita agi kor diyandu. Prisoner's petition has been received from jail at Flag C regarding engagement of Miss Dinapani Tripathi instead of advocate Sanjeev Kumar Das. Stop. Binapani Tripathi has already filed the Wakalatnama for the appellant. The Wakalatnama is accepted. The name of Sanjeev Kumar Das shall not be reflected in the first list henceforth. Stop. The learned counsel for the appellant, so also the learned counsel for the state submit that since paperwork has already been prepared, they may be given a copy of the same. Let the registry supply the paper book to the learning council for the respective parties to talk this matter. Give a date, yes. Next.
39.
39. I will be
Mr.
permitted to collect the deposition copy.
Jafrullah, you have that after they departed, the deceased was alive. She was standing with this man, Chintamani and another. So let us say they were torturing her, so that's a different offense. How do you implicate under 302201? We are telling about this husband and wife.
There is no 120B or anything.
ସେମାନେ ସେଇ ତାଙ୍କ ରହି ପଢୁଥିଲା ତାଙ୍କର
ହଁ ପଢୁଥିଲା ସିଏ ମଧ୍ୟ ଗୋଟେ ଏଭିଡେନ୍ସ ଅଛି ତାଙ୍କୁ କିଏ ଗୋଟେ ପଚାରିଲା ସିଏ ରାଜି ନଥିଲା ଆଉ ତାଙ୍କ ଘରକୁ ଯିବା ପାଇଁ ଯଦି ବି ଆସେ କିନ୍ତୁ ଫ୍ୟାକ୍ଟ ରିମେନ୍ସ ଯଦି ଏଇଭଳି ଏଭିଡେନ୍ସ ଅଛି ଯେ ଘଟଣା ଦିନ ସେମାନେ ଇଏ ଛାଡିକିନି ଗଲା ପରେ ବି ଡିସି ଜୀବିତ ଥିଲା ବଟ୍ ସି ୱାଜ ଇନ୍ ଦି କମ୍ପାନୀ ଅଫ ଦିସ୍ ଚିନ୍ତାମଣି and how do you ଆଉ ଆସିଲା ବେଳକୁ ଅଲରେଡି ଫାୟାର ହେଇଯାଇଥିଲା ଯୋଉଟା କି ତେଣୁ ସେଠି ଆସିଲା ମୁଁ କେମିତି ତାଙ୍କୁ 302 କେମିତି ଇଏ କରିବେ ଏ ଯୋଉ ଅଛି 14 of the child year, that's a different matter. We are not on that. And ସେଇ ଲୋକଟା ପାଇଁ 354A ରହିଛି 8 POCSO Act ଅଛି, that's a different matter. But what about this man? He was not on bail, this Chintamani, but these two persons were on bail. What is your submission?
My lord,
You are the
I'll
counsel.
submit my written
No, written. Eଠି ଆଣି କ'ଣ ଆର୍ଗୁମେଣ୍ଟ ହଉଛି ଫାଇନାଲ ହିୟରିଂ ନା ଆପଣ କେମିତି ତାଙ୍କର ବେଲର ଇଏ କରିବା ପାଇଁ କ'ଣ ଇଏ କରୁଛନ୍ତି କିଛି ମ୍ୟାଟେରିଆଲ ଅଛି ଯୋଉଟା କି ଆପଣ ଦେଖେଇ ପାରିବେ ତାଙ୍କର except that the victim was staying and prosecuting her studies class 5th ରେ ନା କ'ଣ ପଢୁଥିଲା ଆଉ ଏଭିଡେନ୍ସ ଅନ୍ ରେକର୍ଡ ଅଛି ଯେ ଏ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ଦି ଜଣ ଯାକ ସେଦିନ କଟକକୁ ଯାଇଥିଲେ ଏବଂ ସେମାନେ ଗଲା ପରେ ମଧ୍ୟ ଭିକ୍ଟିମ୍ ଜୀବିତ ଥିଲା ଏବଂ she was standing in front of the house with ଏଟା ହଉଛି prosecution evidence ଆପଣଙ୍କର ସାକ୍ଷୀ କହିଛନ୍ତି
My lord, it is a fact that these two accused persons were not present during the house burning.
302 କେମିତି ଆଣିବେ ଆମେ ପଚାରୁଛୁ
During the inquest, the report given by the informant in the inquest format, there is an allegation of informant that his daughter is murdered by this way.
ଆପଣ ଲେଖିଦେଲେ କ'ଣ ହେଇଯିବ କି ମର୍ଡର ଯେ ହେଲା ଠିକ ଅଛି ମର୍ଡର ହେଲା ବଟ୍ ହ୍ୱାଟ ଆବାଉଟ୍ ଦିସ୍ ଟୁ ପର୍ସନ୍ସ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟ ଆପଣ କ'ଣ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟଟା କେତେ କ'ଣ ଲେଖିଛନ୍ତି ଆପଣ
ଦି ଜଣ ନଥିଲେ ସେ
ଜଷ୍ଟ ଇନକ୍ୱେଷ୍ଟ ରିପୋର୍ଟରେ ଆପଣ ଲେଖିଛନ୍ତି
ମାରି ରନ୍ଧା ଆଲାଦା ଯେତିକି 3ଟା ସମୟରେ ଚକ୍ରଧର ନାୟକଙ୍କୁ ଘରେ ନିଆଁ ଲାଗିଯିବାରୁ
ପୋଡ଼ି ମରିଯାଇଅଛି ଏହାକୁ ଦୁର୍ଘଟଣା ଭାବେ ମୁଁ ବିଚାର କରେ ଏଇଟା ଇନିସିଆଲ ଷ୍ଟେଜ ୟୁପି କେସ୍ ବୋଧେ ଏଇଟା ତ ଘଟଣା ହେଲା
ସେ ତ ଚକ୍ରଧର himself is also a witness for that.
ଆଚ୍ଛା ଏଇଟା ହଉଛି 27/3/2017 यार एफआईआर केବେ ହେଇଛି
occurrence situation
29/7/2017
ଓ ମାନେ
1 month ago.
and UD case has rested thereafter
FIR ଟା ବି exhibit ହେଇନି ଠିକ ଅଛି
primarily it was a UD case, then
Chakradhar Nayak system. The London Council for the petitioner submitted that the petitioners are the husband and wife and they were on bail during trial and the case is based on circumstantial evidence and there are materials available on record that the deceased was prosecuting her studies in class 5th, staying in the house of the petitioners. And on the date of occurrence, after the petitioners left their house, the deceased was seen alive in the company of Chintamani Biswal, the appellant in JCRLA number 8 of 2025, against whom the allegations are under section 354A, so and so, and 8 of the POCSO Act. The Land and Council further submits that the occurrence in question took place on 26/3/2017. However, in the first information report, which was lodged on 29/4/2017, that is a month thereafter, even the name of the petitioners are not there as accused, and it was lodged only against Chintamani Biswal. And at a subsequent stage, the petitioners have been falsely entangled. It is further argued that in view of the available materials on record, there are good chances of success in the case and balance of convenience lies in their favor. Therefore, the bail application may be favorably considered. Land Council for the state opposed the prayer for bail. Land Council for the informant also opposed the prayer for bail, considering the submission made by the Land Council for the respective parties, absence of any direct evidence, nature of circumstantial evidence on record, fact that the petitioner were on bail during trial, absence of any chance of early hearing. We are inclined to release the petitioners on bail allowed.
So far, my case is concerned, my lord.
That is after PR petition. Yes, next.
My lord, there is nothing against me also, so kindly have it.
Yes, next. 41.
Item number 41.
No, please move up. The appellant stands charged under section 302 and imprisoned for life. Madam. There are 14 prosecution witnesses. And one, I will.
We took up the matter on 24/6/25. The report of the senior superintendent was produced, and it indicates that you are in custody for 9 years, 6 months. And we sought for instruction regarding antecedent. What is the case against you? Your bail application was never rejected earlier. It's a 302 case.
Yes, madam. One, I.
Double murder case.
Acha. Who is the eyewitness?
PW8.
PW8 is the eyewitness.
I has not examined the Indian matter.
Just a moment.
What is your submission? It's a case of double murder. The eyewitness has implicated you.
My lord, the false case, my lord, maybe.
How do you say,
My
unless
lord,
the eyewitness statement is demolished, what have you, we are verifying that cross-examination. What has been
My lord,
brought out in the cross-examination to disbelieve? Because the first assault took place while one of the deceased was sleeping there. ସେଠି ହଠାତ୍ ସିଏ ଦେଖିଲା ବେଳକୁ you found that 2 blows were given by axe to Suru Dharwa. He is one of the accused. Then when shouting, he shouted this eyewitness, and then you fled out. Then on the way near the field, you assaulted another, that is Lalit.
Lalit
Gone to the call of nature.
And he also became unconscious and subsequently died. There was, and you have brought out also in the cross-examination, paragraph 4, that there was previous dispute
Yes.
between the accused and the deceased persons, for which both of them had been shifted to my room. So this is the thing.
Previously, they were working in the same company and were working, but the IO has not examined properly. That MO has not been examined, and forensic report has also not received. And I also examined the owner of the house, the hutmate, the Lucky Singh. He has not examined. He has not seized the proper
The person
identification.
was sleeping near the deceased, one of the deceased at least, and the other deceased had been to attend call of nature.
Yes, sir.
He has stated that they were staying with me in one room in the premises of Bhushan plant, and they were sleeping inside one house, and you gave the blows, he got up, shouted, and you fled away. That is one. Then the second one is that near that attending the call of nature, there assault was made. So tell us something, what have you brought out? It's not a case of, it's a double murder case.
Yes, the DW won the, has also accepted that some nephew of the IO is not examined by the police IO. The he has also stated that there's some false implication, and they are calling for the implicated from the false case. And the accused also mentioned that he was not arrested. The IO has stated that he has arrested at the police station, near the railway station something. But accused has denied that he was working at the some.
Right, the appellant, the learned counsel for the state has produced the written instruction. Delegi, written instruction on the criminal antecedent of the petitioner, which is taken on record, put up after Durga Puja holidays. Yes, next.
Number 42.
Mr. Jafrullah.
My lord.
Lord, in this case, I am appearing for the informant. Last time, this case,
What do you want?
time, I pray for time.
You have got the deposition copies.
Bikes, there is deposition.
Deposition copy tada
You are having. All right. Has entered appearance for the informant. Is present.
Item 43.
The Lordship's Senior Counsel D. Nayak will be arguing this matter. However, we have not obtained the paper book, but I'll obtain it today. Thereby, we would need some time for preparation.
State realization of my senior advocate ଆସିବା ଦରକାର
478 of 2005. There is no bail application. It's only for stay realization of fine. For that purpose, what is the necessity of the senior advocate addressing the court? This case number, IN number 478. Or the stay realization of it. Bail tak is 9. Is there any application for bail, Mr. Nayak?
No, my lord. Report that is
The bail application upon the dispose of it.
2007.
2007
7 days already.
ବେଲ୍ ହେଇଯାଇଛି କଣ ଆପଣ ଚାହୁଁଛନ୍ତି କଣ ଏଇଟା ଅର୍ଡର୍ସ ପାଇଁ ଆସିଛି ଷ୍ଟେ ଆପଣଙ୍କ ନାଁ କୁହନ୍ତୁ
Your Lordship, the fine may be stayed.
ହଁ ସେଇଆ କୁହନ୍ତୁ ଆପଣଙ୍କ ନାଁଟା କୁହନ୍ତୁ
Chetna Prakash.
ନାଁଟା ଲେଖିନାହାନ୍ତି IN number so-and-so, hard miss so-and-so. There shall be stay of realization of fine till final disposal of the appeal. Yes.
Item 44.
On behalf of Mr. Pandai, this form.
There is stay of fine ଅଛି stay fine state କରିଦିଅନ୍ତୁ
Okay, the lordship. On behalf of Mr.
ଏଇଟା ବି ଅଛି fine state ପାଇଁ
Again.
fine state. Yes, next.
Item 45.
मनोज पट्टनायक तो ये बोलेनी और किए बुझुचंदी किए तांकर केस पास
Reports.
के नायक जी नहीं थी ना ठीक है जी
ଆସିଛି
नहीं
Report को जी
ଆଚ୍ଛା ଆଚ୍ଛା ସେଥିରେ
नंदा मच्छी डाइट है
ଆଗରୁ ଦେଖିଥିଲି
45 रे कहीं वो रिपोर्ट ऑफ द ओआईसी
43 ରେ ଚାଲିଥିବ 43 ଥିଲା ନା
43 ରେ कौन थिला
ରିପୋର୍ଟ
43 ରାଲି ବି ଅଛନ୍ତି
43 ଟା ବାର କଲ ଲେଖି ଦो
nothing at all. ଅଛନ୍ତି there like that
43 ରେ ସେ ବେଲ୍ ପରେ
लिख दियंतु सी जो स्टे ऑफ रियलाइजेशन ऑफ फाइन हला ता छला लिख दियंतु पे यूज द रिपोर्ट ऑफ द dated 14/8/2025 of the IAC Bodasai police station which shows that the appellant Sikal Mohanto is alive हला सेति खाली करदो तापरे 44 रे किछ अछि रिपोर्ट नै तो 45 रे रिपोर्ट ऑफ द ओआईसी अछि रिपोर्ट ऑफ अपन अच्छा एक गोटे की एक्सपर्ट करियन was transferred to Sahoo presently. So गोटे एक्सपर्ट करछि कोन संबोडू माझी कितना नंबर अपना नंबर
संबोधु माझी अपना 2
अपना नंबर 2
टैग
एटा को लिखि जंतु पेरी दी रिपोर्ट अच्छा एटा 2020 रो रिपोर्ट आ गोटे लेटेस्ट आना
ଏଟା 20 ରିପୋର୍ଟ
एटा गोटे को अपडेट करि दउ बाकी गोटे फ्रेश रिपोर्ट ओडा नै गिना आसंती लिख दियंतु पेरी दी रिपोर्ट dated so and so of the OIC which indicates that appellant number 2 Sambodu Maji is dead है ना ये लिखी देवे अपील अपडेट्स कर देवे so far as appellant number 2 is concerned Guardian counsel for the however it is indicated that appellant number 1 and 3 are alive however since in the meantime about 5 years are going to be elapsed let a fresh report be obtained from the concerned police stations regarding the well-being of appellant number 1 and 3 है ना परमिशन को तो पेड दे दे एटा आनी भी 1 और 3 रो अच्छा ये अच्छा आसी जाओ रिपोर्ट कारण thereafter we will engage somebody because they are not appearing No, no, Bonoj Patnaik भी आके नायक भी जाइछन ई जो
report এটা না
बाकी
delete হবে
बाकी दी जन से डिलीट हबो
পি সিনহা and
बाकी
PK
पी सिन्हा
PK
पीके साहू की
Sinha is associate.
हां
Sinha is the associate of Manoj Patnaik.
খবর
तांको की खबर दे देबे ना अच्छा मिस्टर बोनस
R.K. Naik also, Ranjan Kumar Naik.
वो या रंजन कुमार नायक
Ranjan Kumar Naik. There is the Prasenjit Sinha in that case.
खाली मनोज कुमार पटनायक को नाटा एक्सक्लूड कर दो जो लेकिन डिफेंस मिनिस्टर मनोज कुमार पटनायक इज डे is no manner to reflected in the first list. Yes, next.
46.
I'm grateful to you, Manoj Kumar Patnaik.
46. Matter of
Letter
2005.
issued to the DG of Police for obtaining instructions. You will be informed of
Varsini.
Varsini. Premature release or you find?
Both contract.
It appears that the report as which was addressed to DG of Police for obtaining instructions regarding well-being of the appellants or about their premature release has not been received. And counsel for the state seeks some time like those,
Okay.
to obtain the report put of this matter after the holidays.
Today morning I reminded all people.
I seen the report as
7/8/2025 এটা কোন রিপোর্ট
okay, book number
এই
36
419 তো
419 no 47 419 no in continuation something on additional list of 141 institution is sent for obtaining the other instruction
দল গেছে
DG of police as well. All right, the learning council for the state seeks some more time to obtain instruction from the DG of police regarding the well-being of the premature release of the appellant, after puja holidays go on.
At 48.
Same also.
Same model. After puja holidays.
49.
Report my finance.
Okay, report says letter will be issued not. Letter issue in
49.
49.
हमने तो ऑर्डर कर दीजिए ଗୋଟେ कॉमन ऑर्डर ହେଇଛି ନା
हाँ से जाइए किछ किछ फाइल रहि जाइए
ନାଇଁ ନାଇଁ ଆପଣ ପଠେଇଛନ୍ତି ନା ନାଇଁ ଆପଣ ପାଖରେ ନାଇଁ
नहीं नहीं এটা যাইনি
पठेଇ दियନ୍ତୁ
आगे
the learning council for the state submits that as per the order of this court in connected cases he wants to send a letter to the DG of police for obtaining instruction regarding the well-being of या नाडा कौन इम्तिया नाडा वाल्टर कौन
वाल्टर बासिल्वा
पूरी आड़ी ये लोग इंदर बाज this and also the premature release ये छुट्टी पर हो गई after puja holidays next
50.
50 with the letter face letter release
letter to be issued so other letter issue करिए तो puja holiday next
51.
Your Lordships, I pray for the stay of realization of fines.
The report मंगाया था
just a minute report of the IAC Kanpur regarding well-being and whereabouts of the appellant received achura clerk के दे clerk के
following persons who is appellant in Natigi pending upon the is informed that the appeal will be taken upon release that wherever request that the Bujulman
असला report कौन असला
Gundi Kanpur report of complaints and asking and a subsequent developer asking
କୋଡିଏ ମାସ
ନା 20 ମାସ।
ଏବେକାର ଏଇଟା ଆଗରୁ ଦିଆଯାଇଥିଲା ବୁଦ୍ଧିମାନ ସାହୁ is mentally and physically fit, maintaining his livelihood.
Fresh report.
এটা ଲେଖି ଦିଅନ୍ତୁ ଯେ though the report is available on record regarding the well-being and whereabouts of the appellant, but it is dated 2/2/2021. The Learned Counsel for the state seeks some more time to obtain the up-to-date report in that respect. ये आपका पूजा holidays कर दूँ. Next. 52.
52 ରେ ଆମର ଇନଫର୍ମେସନ ଯାଇଥିଲା ସେମାନେ ଗୋଟେ ରିପୋର୍ଟ ଦେଇଛନ୍ତି କିନ୍ତୁ ଖାଲି ଲିଭିଂ ୱିଥ୍ ବାୟୋଲୋଜିକାଲ ଫାଦର ଅଛି କିନ୍ତୁ ଯୋଉ ମେଲଟାରେ ଆଟାଚମେଣ୍ଟ ନାହିଁ we are intimated to provide this. The daughter have filed the petition for release of the deposited amount by the appellant at the time of bail granting bail.
My lord, I filed fresh wakalat amendment.
Where is your wakalat now?
Sir, filed on 12th of
10/8/25.
my lords.
In the name of Shaumik Spandam Tripathi.
My lords.
तो शिव शंकर पटनायक किए.
My lords, the appellant, my lords.
शिव शंकर पटनायक is the executant in the wakalatnama. Who is he?
Sagar Patnaik alias Shivasankar.
वो तारा ना था.
My lords.
Appellant.
My
So you have preferred this appeal, criminal appeal,
my lord.
challenging the order of conviction.
My lords.
498 is 2304.
Okay. So what is the prayer here in this petition?
Daughter have filed the IA to release the deposited amount, bail bond amount with the deposited by father, which is remain in the fixed deposit. After being attained majority, she has filed this petition for release for her study purpose.
Just a minute. 16/7/25. Please read out the order. Let us see that. So 7/25 order.
The interim application has been filed by the daughter of the appellant.
हाँ हमने लिखी जुदा है 16/7/25 order that he placed from.
My lords.
Learned counsel for the petitioner product.
My lords. Learned counsel for the petitioner submits that by day order dated 28/9/2011 passed in miss case number 1326 of 2009, the appellant was directed to be released on bail inter alia with the condition that he shall deposit a sum of rupees 1 lakh in the name of his daughter in any nationalized bank or post office for a period of 6.5 years with the renewal clause for another equivalent term and furnish the cash certificate brackets postal certificate or term deposit certificate before the trial court with an undertaking that he shall not mortgage or pledge the same and the learned trial court shall intimate the same to the post office or the bank as the case may be accordingly. Learned counsel further submits that in pursuance of such order, the appellant deposited a sum of rupees 1 lakh and he was released from custody. And at this juncture, the daughter of the appellant
was kind attention to 6th August order, your lordship was kind enough to take instruction certificate, custody certificate, conduct and incarceration of 14 years, more than 14 years by now.
Only that criminal antecedent report, some other report I pray for some time.
The Learning Council for the state has produced the report received from IIC
Patna.
to also regarding the criminal antecedent of the appellant. However, he submits that he may be given some more time to obtain the reports as per the order dated 6/8/24.
Yes, sir. Let's say,
Put up this matter, give it a wait.
let,
अच्छा, the report is taken on record.
last week, September.
देखियो से तो।
Oblige.
Item 54.
May I please ask? Discuss my lord. On 25/7/2025, my lord, you will also direct state council to obtain instruction, my lord. Regarding the.
Interim bail आपण ଯାଇଥିଲେ।
My lord. 2/9/2024.
कौन ଆସିଲା?
Neither involved in any other criminal case nor involved in any criminal activities in any manner.
କେବେ ଯାଇଥିଲେ interim bail?
My lord, 2/9/24.
କେତେ ବର୍ଷ ରହିଲା ପରେ ଯାଇଥିଲେ?
12 ବର୍ଷ 7 ମାସ ରହିଥିଲେ। ବର୍ତ୍ତମାନ 13 ବର୍ଷ 6 ମାସ।
Undergone 12 years, 7 months of such conviction.
Now 13 years.
କିଛି ଗଣ୍ଡଗୋଳ କରିନାହାନ୍ତି?
ନାଇଁ।
Three
302, 304B, 493.
You have killed your wife, that is the allegation.
That is the allegation, my lord. But really in a very
brutal manner.
with regards to my lord, the
No, we are not deciding the appeal though. Is in custody and his behavior conduct was good. That was the thing which we wanted to know. That's it. You surrender at right time.
right time. At the current settlement there.
Now you must have undergone 13 years of sentence.
And 13 years, 6 months, my lord.
Are the Learning Council for the Petitioner Learning Council for the state. The Learning Council for the state has produced the report from the IAC Jamankira police station to show that during the interim bail period, the petitioner is not indulged in any criminal activities in any manner. Stop. The report is taken on record. Considering the submission made by the Learning Council for the petitioner, that the petitioner has remained in judicial custody for more than 13 years and absence of any chance of early hearing, and more particularly since the petitioner has not misutilized his liberty while on interim bail in view of the decision rendered by the division bench of the state in case of Lakey versus Swanson. The bail application is allowed. Yes.
Item 55.
Upon application for interim bail, the petitioner, the appellant is in custody since 9/9/2014. Earlier, this honorable court was pleased to grant an interim bail for 3 months. Accordingly, he was released on 14th March. After getting the bail order on 6/2/2023, he was released on 14 March 2023, and accordingly he surrendered on in the month of June. I have also filed the surrender certificate. Custody certificate, your lordship directed to obtain the custody certificate.
Custody as well as detail upon the last word of the first year. এটা তো খালি কস্টডিটা আছে।
And the item during interim has its content was good. Written report of the villagers of the village Kundul and protection address.
ଆମେ ଯାଇଥିଲା written report of the villagers ମଧ୍ୟ ଆଣିଛନ୍ତି। Hospital certificate ଦେଇଛନ୍ତି 10 ବର୍ଷ 5 ମାସ। ତ ଇଏ ଗାଁ ଲୋକମାନଙ୍କର
Villagers have given the state
ପ୍ରଦର୍ଶନ ଠିକ ସମୟରେ এটা ତାଦେହରୁ କାଢିଦେଲେ କାହିଁ ଚିପ୍ ଦେଲେ এটা ଷ୍ଟାଫ୍ ଲୋକ ପ୍ରୋଜେକ୍ଟ
tag ହେଇକି ରହିଲା ଖୋଲିଥିଲା।
ହଉ ଠିକ ଅଛି ଠିକ ଆପଣ ପାଖରେ ଗୋଟେ କପି ରଖୁଛନ୍ତି ତ?
ନାଇଁ ନାଇଁ ସେ
କପିଟା ରଖିବେନି କାଲି ସକାଳେ ଦରକାର ହବ ଆପଣ ସବୁର କପି ରଖିକି ଦେବେ ରେକର୍ଡରେ ଗୋଟେ କପି ଦେଇଦେବେ। The Tribunal councils of the state, as per the order dated 5/5/2025, has produced the custody certificate received from senior superintendent for us, so that the petitioner is in judicial custody for more than 10 years. Same is taken on record. He has produced another report from IIC, Pottangi Police Station. It shows that the conduct of the petitioner during interim bail period was good. The custody certificate as well as the report are taken in record. Considering the submission made by the Learning Council for the respective parties, period of detention of the petitioner in judicial custody, absence of any chance of early hearing, and since the petitioner has not flouted the terms and condition of the earlier interim bail order, we are encouraged to release the petition on along.
Item 56.
My lord, IN number 9/40/2025. Convicts for life imprisonment offense committed under section 394, 303, 201.
ठीक है मैडम।
My lord,
आगुरु आपनकर बेल रिजेक्ट
3 months.
3 month जाइथिले
My lord.
जाइथिले
My lord. 4/12/2024.
सरेंडर ठीक समय कले
Right time जो करछंती.
कोन आपनकर कंडक्ट
My lord, custody period 15 years 4 months.
report
portal
My lord, generally subordinate evidence, no eyewitness.
Learning Council for the state took some time to produce the custody certificate as well as the conduct of the petitioner while he was on interim bail as per the order dated 4/12/2024. No, put of this matter, the date of event, yes.
Item 57.
May I please your lordship? My lord, my who has to all 3 persons have been released on bail by the honorable the annexes 1 and 2.
There are 2 matters. Which matter you are meaning?
I don't know this one, my lord. I pay so that from next week, my lord, file is not with me.
File is not with you. Next week,
Next one.
would have the instance of the state for the and council for the state 6 for an adjournment next week. Yes.
Item 58.
My lord, I can report.
Yes, Mr. Sahu. Report for this. Report mangaitila.
Yes, in field of the process.
Yes, the employer, however, advised to surrender to custody after expiry. We have predicted.
Surrender kale.
Yes, sir.
Surrender certificate kain.
I need to know.
File korchandi.
I get.
This reputation.
Last day. Asi report asi. Conduct.
Report.
Asini. Anam to them. Order ହେଇଥିଲା ଆଗରୁ ନା ନାହିଁ? The Learning Council, IN number 1, is an application for bail. The Learning Council for the petitioner has filed the surrender certificate. Stop. Learning Council for the state seeks some more time. Seeks some time to obtain instruction relating to the conduct of the petitioner while interim bail as per the order dated 18/3/25 though. As per the order dated 18/3/25. So also the custody certificate for them, no? Put up this matter, give a date. Yes.
Item 59.
And your lordship, I pray, can you take it up next week?
Yes.
Item 60.
Mr. Mishra.
Yes, my lordship, in this matter, I am through VC, my lords. In item 60.
This.
Yes, Lord. At flag E, the prisoner's petition.
Prisoner's petition has been received.
Flag E.
For engagement of one show. Okay. In case of Mr. Kupuna Mishra. So that is dated 21/7/25. But Mr. Kupuna Mishra has also filed wakalatnama seta kibe karo.
It was like 2-3 days, 19. 2-3-19.
So Mr. Manohar, where is your wakalatnama?
My lordship, it's already on the record.
Wakalatnama, and these are the receivings I got from the filing counter. So these are the receivings.
All right. So that is not available in the record. So that is how. Mr. Sam Manohar, Learning Council appears to virtual mode. Prisoner's petition has been received.
Lordship, I have filed wakalatnama at least 1 month ago. The exact date of receiving is 28th July 2025.
The power of attorney and zero
Power of attorney कौन पढ़ा है किधर?
Professor Pani Lai. Sam Manohar, the power of attorney.
It's not the wakalatnama.
No. So yes,
You have to file the wakalatnama. So
yes, affixed the court fee.
Here in Honorable High Court of Delhi and Chandigarh, they tell it by power of attorney, but the effect of both the is same, lordship. And then if the lordship directs, I will file.
You file wakalatnama. That would be better. The Learning Council, Mr. Manohar submits that he would file wakalatnama. Put up this matter after filing of wakalatnama. We are not fixing any date, just file that
Yes.
Wakalatnama, and it will be automatically listed, okay?
My lords, I
And
will file.
you are in custody for how many years?
Lordship, 9 years and 3 months.
Meantime, the Learned Council for the state shall produce the custody certificate and also obtain inspection regarding the criminal antecedent, if any, against the petition.
The demarcation copy.
Deposition
copy not.
Deposition.
Already, everything has been done. Paper
I
book
will
is
serve
ready,
in the
lords.
meantime, and these are the custody certificates. I am just submitting. My lord, kindly take it on record.
Have you got the deposition copies with you?
I will serve deposition copy in the meantime.
The Learned Council for the appellants shall serve the deposition copies on the Learned Council for the council. As a custody certificate has been produced out of the 9. Custody certificate has been produced by the Learned Council for the. You give a copy to him.
I have already served.
Copy of the same has been handed over to the Deleta.
Yes, lord, I have served it.
To the Learned Council for the state. Serve the deposition copies. So now, once you serve the deposition copies and this Wakalatnama comes, or you file it, then it will be listed automatically. Okay?
Yes, lordship.
Yes, lordship.
I'm obliged.
Item 61.
Please, your lordship.
Yes, Mr. Panda.
I am in custody, having been convicted on section 302 of the Act.
Earlier rejected or first time?
No, earlier your lordship granted me 3 months base.
Very bad.
Order dated 22/24.
Sure. You surrender at right
Yes.
time. What is the conduct report?
The conduct.
Get it? Why are you not? This is the usual order. In every bail order, we are mentioning that you are to obtain that. But again and again, you are asking for time. That's from the IN number 2182 of 2025, 2182 of 2023 from लिखा है जी। वो तो भूल ले लिखा है जी तो scanning.
Surrender certificate has been filed with.
No. There are 25 over 25. And this is an application for bail. Mr. Devashish Panda Land Council for the petitioner submits that after availing the interim bail period of 3 months, no? 3 months, as per the order dated 22/8/2024, the petitioner surrendered at right time.
On 28/11/24.
On 28/11/2024, and he has annexed the surrender certificate to the interim bail application. The Learned Council for the state have take some time to obtain the report from the concerned IIC relating to the conduct of the petitioner while on interim bail. Of this matter. Yes.
Item 62.
Yes, I have moved for bail, my lords, because the petitioner who was in custody, my lords, the prayer for bail was rejected. The criminal appeal was directed to be heard. In fact, it was in your lordship's list before the vacations. But thereafter, since it was not lifted, I am seeking for bail. Because the petitioner has been in custody since 6/6/2017.
Mr. Panda, just the report of the dealing assistant. It accounted. Report of the dealing assistant. Computer filing.
Custody certificate is on record.
Surrender certificate not filed. Land Council in this regard. The report of the billing assistant from the value section at previous page.
This for plan number 2.
State to produce a report regarding part of the ପୂର୍ବରୁ ବୋଧେ foreigner certificate ଅଛି। Foreigner certificate is found to have been filed during the period from 22/4/2025 to 25/4/2025. Highly
As surrender लिखा है जी 8/5/2025 and he has also filed the surrender certificate. Here's the memo on record. Now, what is your submission, Mr.
Lord, I
Panda?
have been in custody since 6/6/2017.
When you are released on bail, you appellant number.
My lord, initially for once your lordship granted me bail on 26th of February 2020 for a period of 4 weeks.
Just a minute, tell us the date first.
26th.
appellant number 2 तो?
आइए।
प्रथम केबे गले?
26th February 2020.
26/2/2020
ଆଜ୍ଞା।
ସେତେବେଳେ କେତେ ଗଲେ?
4 weeks.
4 weeks ତାପରେ
ମୋ ଭଉଣୀ ମରିଗଲା, your lordship has granted me bail for 1 week on 28/3/25.
28/3/2025 1 week.
ଆଜ୍ଞା।
ସେଇ ଭିତରେ ଯାଇଛନ୍ତି।
ଆଜ୍ଞା।
Anything adverse reported?
The report has not received.
Get the report he has filed. Because though he has filed an application for early disposal, but he has also filed an application for bail of appellant number 2 only. No. So,
I am appearing only for number 2.
So number
1
2
has taken counsel.
custody certificate
Custody certificate is there on the record. Order sheet dated 16/1/2025, my lord.
Order sheet
16/1/2025.
16/1/25. The Overseas Fund Bank Council fund was taken into custody. Submitted the appellant number was taken into judicial custody. No, custody certificate means total period.
Your lordship called for the judicial custody certificate also on that.
Is it available with you? Achha.
Order dated 29/1/25.
7 ବର୍ଷ
12 ଦିନ।
26/1/2025.
7
That is
ମାସେ 12 ଦିନ।
So just get that instruction about that period only. Mr. Devashish Pandal and Council submits that the appellant number 2 is an application for interim bail of appellant number 2 लिखिले ତା ନାଁଟା ହଉଛି
ବାବୁଲି ସାହୁ।
ବାବୁଲି ସାହୁ. We submit that appellant was directed to be released on bail
Interim.
By the order dated 26/2/2020 for a period of 4 weeks. And again, he was directed to be released on bail as per order dated 28/3/2025 for a period of 1 week. And on both the occasion, after availing the interim bail period, he surrendered at right time. Stop. The London Council for the state seeks some time to obtain the report on the conduct of the petitioner while on interim bail on 2 occasions. Put up this matter. Keep that there, correct? Yes.
Item 63.
There is a petitioner petition is there. Appearing.
The engagement of Mr. Deepak Ranjan Mishra.
I am appearing for appellant number 3, madam. Dullu Sundhi.
And এটা কাহার মানে prisoner petition মানে
For mine,
Bullu কোন
Dullu Sundhi, madam.
Sundi. So how many appellants are there?
3 appellants are there
Acha.
in this appeal.
So you are only appearing for
Dullu Sundhi, appellant number 3, madam.
So obviously this Mahato etc. they will appear
My
for
lord, say they are
this one. Now what you have filed, any application?
Application, previous application is there.
No, that will allow you to appear, but
My lord.
any application has been filed for?
No.
Prisoner's petition has been received for engagement of advocate. Prisoner petition has received from appellant number 3. Look at the now Dullu Sundi for engagement of Mr. Deepak Ranjan Mishra, advocate, in case of previous counsel. Mr. Mishra has already filed Wakalatnama. The Wakalatnama is accepted. Now, Mr. Rohit Mahato shall continue to be the advocate for appellant number 1 and 2. Stop. And Mr. Swanso, Mr. Mishra will be the advocate for appellant number 3. Stop. Baki Leki Jantu. IA number Swanso is an application for bill put up after Durga Puja holidays. Yes.
Custody certificate because appellant is present
On the file करना चाहिए इसमें पचार जो पड़ा अपन file करना तो file कर ले मुझे ना कौन
Okay.
yes next
Item 64.
Maybe. But I'm saying that because I thought this one of the last topic I'm filing a new application for payment.
last order was passed on 26/6/25. He wants to file a place interim application
Yes.
highlighting the present status of the petition. File कर ले.
Yes, ma'am. That is on the comment.
That is 2257.
Yes, ma'am. That the appellant challenge the conviction order dated 29/10/2019. Order says 302. For punishment.
Your bail application was earlier rejected.
No, ma'am. The application was filed by the previous council. I am engaged in
No,
this.
the previous council won't upon reject nine because it's a criminal appeal of the year 2019. That is why we are asking whether it has been rejected or not. If not rejected, it's all right. Okay, so it has never been rejected. You just
Not press the please.
not press the earlier application to file a better one. Accordingly, you have filed. You have received the copy of the interim application.
No.
Copy doesn't end.
And also
deposition copy. Deposition copy दियंतु और IA रो copy टा दियंतु. लेखन IA number 2257 of 2025 is an application for interim bail. Learned counsel for the petitioner sought the copy of the interim application on the learned counsel for the state, and he submits that he will supply the deposition copies to the
last of it in order that deposition copy in respective pen types. I will also get the copy from this.
अच्छा you trial court record पहुंच जाइए ना soft copy अच्छी the learned counsel for the learned counsel for both the parties are permitted to take the deposition copies of the witnesses in their respective pen drives from the soft copy of the trial court record. All right, put up this matter given.
I beg pardon, my lord. One more prayer. I will kindly permitted to take the TCR copy of the TCR.
No, you will be allowed. TCR, so many things are there. TCR means case diary to आरंभ करी सब
Only paper book you are entitled.
Paper book you are entitled to. So deposition copy देवे आपनकर जो order sheet सब जिनिस अच्छी ना अपन पूरा total trial court record. You for moving the bail application you require the deposition copy. That you are supplying.
That
Yes.
Oh, bless you. Copy already served. Copy already served.
We have noted down the copy. Yeah.
Item 65.
Peruse the order dated 28/7/2025. That was for the appellant number 2, conduct of the appellant number 2.
Maheshwar Maji.
Below.
Anile.
No.
Next week or those next week. Learned counsel for the state. 6 adjournment till next week to comply the order dated 28/7/2025. Put up this matter now. Yes.
No, sorry,
Asti, Gion.
Maybe interim bill is
conduct term. This application filed by both the appellants, no?
Miller.
Earlier you filed the written instruction in respect of appellant number 1 only. Now you are producing number 2, Maheshwar Maji or anything else? এটা আপনারা আগুরু প্রডিউস করছিল কোন কইবে মানে we have noted down there in the that you have produced this document that relates to only appellant number 1 Mangal Sai Bhatra বুঝিলে না ଆପଣଙ୍କୁ ସେଇଥିପାଇଁ ଯେହେତୁ ମହେଶ୍ୱର ମାଝୀ ଯିଏ appellant number 2 ତାର ପ୍ରଡ୍ୟୁସ କରିନଥିଲେ ସେଥିପାଇଁ ଆପଣଙ୍କୁ ଆଡଜର୍ନମେଣ୍ଟ ଦିଆଯାଇଥିଲା ଆପଣ ପୁଣି ସେଗୁଡା ଆଉଥରେ ଦେଇଦେଲେ ଆଜିର ଗୋଟେ ସିଲ୍ ବସିଗଲାଣି ତାକୁ ଏଇଟା ଫୋଲ୍ଡ କରିକି କେମିତି କଣ ଦିଅ
କପି ଗୋଟେ ଅଛି
ଅଛି ଅଛି ତ ରଖିଦିଅ ସିକ୍ସ ସମ୍ ଟାଇମ୍ ଯେ ଆଗରୁ ଥିଲା ଅର୍ଡରଟା ସେଟା ରଖିବି ନେକ୍ସଟ
Item 66.
Master Judge Lordship directed to state to take instructions on victims whether he let this appeal.
ଓ ଏଇଟା ଯୋଉ ପୋକ୍ସୋ ଆକ୍ଟର ସେ ଲିଗାଲ ଏଡରେ ଦବ କି ନାହିଁ ଆଗକୁ କଣ ସେ କହିଲେ ଖାଲି ସେତିକି ହେଲେ
The order dated 28/2024. The appellant number 1 petitioner, he was released on interim bail for a period of 3 months.
कौन ହେଲା ସରେଣ୍ଡର କଲେ
हाँ surrender करे timely surrender करते थे.
କାଇଁ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ କାଇଁ
Certificate sir ମୋ ପାଖରେ ନାହିଁ surrender करते थे state में agree.
ନାଇଁ ତ ସେ ଭେରିଫାଏ କରି ରିପୋର୍ଟ ଆଣିବେ ଦେଖନ୍ତୁ
Sir both certificate କେବଳ petitioner 1 ପାଇଁ କରାହେଇଥିଲା. ଏଇ ଯୋଉ IA 414 this for both the petitioners.
ସେ ଯୋଉଟା ଯାଇଥିଲା ସେଟା ସରେଣ୍ଡର କରିଛି କି ନାହିଁ ସେଟା ତ ଆମେ ଜାଣିବା ଦରକାର
ସେଇଟା କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଦି ଜଣଙ୍କର ଏଇ ସାର୍ଟିଫିକେଟ ଦି ଜଣଙ୍କର କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ
Plus IN number 414 of 2015 25 sorry 25 this is an application for bail of both the appellants stop it appears that appellant number 1 Ranjit Malik was directed to be released on interim bail for a period of 3 months as per the order dated 28/24. To the Land and Council for the appellants, Mr. Jena submits that after availing the same, appellant number 1 has already surrendered
on 4/12/2024.
On 4/12/2024, but he has not produced the surrender certificate. Upon anyway, I mean instruction.
Not instruction.
So, but he has not produced the surrender certificate. Stop. Let a report be called for from the Land Trial Court as to whether the appellant number 1 will surrender after availing the interim bail period as per the aforesaid order dated 28/2024. Stop. The Land Council for the state shall produce the custody certificate of both the appellants. है ना? Then the next day. As well as regarding the conduct of the appellant number 1 filed on interim. है ना?
Jail conduct.
Huh?
Jail conduct.
Conduct while on interim bail. ଆଉ custody certificate. ଆଉ ବାକି ସେ surrender କରିଛି କି ନାହିଁ मैं trial court report ଦେବି ଆଉ।
Should be fixing a date.
ଆଜି ସନ୍ଧ୍ୟାବେଳେ ଜାଣିନେବେ ଅପଲୋଡ ହେଇଯିବ।
Item number 68.
May I speak? The present appellant, which in fact on last occasion, my lord, I have produced a copy of the custody certificate. Is near about 14 years, 13 years, some odd month.
ଦେଇଥିଲେ custody
Custody certificate. That is the order sheet of your lordships. That has been filed.
Okay. Now, why this matter was adjourned then?
Because
Land Council states on to obtain instruction relating. अच्छा वो जाइଥିଲେ कि बेल
bail, my
बेल
lord.
केबे जाइଥିଲେ?
That is
23/7/2023
my lord.
कौन
For a
आसला?
period of 4 months.
हाँ conduct कौन आसला? दियो
With the direction to approve the IAC on each Monday.
କୋଉଥିରେ? ସେ ଯୋଉ order ରେ bail order ରେ
Right.
different.
But for 2 months we appeared.
ଆଉ କିଛି ଖାଲି ସେଇ ଗୋଟା ଭାଉଲେଟ ହେଇଛି ନା ଆଉ କିଛି ଗଣ୍ଡଗୋଳ କିଛି କରିଛନ୍ତି କି? 2 ମାସ ଆଇଆଇସି ପାଖକୁ ଗଲେ ଆଉ ଗଲେନି ଆଇଆଇସି କହିଥିବ କାହିଁ ଆସୁଛନ୍ତି ଯାଆନ୍ତୁ ମୁଁ ହାଜିରା ମାରିଦେବି।
There is no direct evidence, nor any clinching
ବନ୍ଧୁ ମେରିଟ ରେ କଣ କହିଲି?
near about 13 years, 3 to 4 months. I'm deducting that interim period. He has been apprehended on 28. What somehow or other he has been forwarded.
Counsel for the state. The Land Council for the petitioner submit that the petitioner has remained in custody for 14 ବର୍ଷ କେମିତି ହବ ଏଟା?
13 years, 4 months.
For custody for 13 years, which would be evident from the custody certificate produced by him. Stop. The Land Council for the state, as per the order dated 28/7/2025, has produced a report from the officer in charge of the police station dated 8/8/2025 to show that no criminal activity has been noticed against the petitioner in the 4 months interim bail period. However, he appeared before the IAC Belpada police station for a period of 2 months, but not for the entire interim bail period. Stop. The report is taken on record. Considering the submission made by the Land Council for the respective parties, the period of detention of the petitioner in judicial custody, and since no criminal activities has been reported against the petitioner while on interim bail, We are inclined to release the petitioner on interim bail for a period of 3 months. And you will report before the IIC IIC Belpora Police Station. Once in a week on each Monday. Agur jahat kiya gaya dekhi lete. No.
Complete.
Item 69.
Appearing on behalf of Mr. L. Samte.
Tinta case achi.
875 by 2020.
87. Yes.
Wakalatnama was filed by J. Samantrai, but
There is sole appellant.
yes, sir.
Criminal appeal का जौने फाइल करचंदी विजय कुमार साहू.
Yes, sir.
अच्छा बिजनेस पिटिशन आसीची जितेंद्र सामंतराय को नारे. अच्छा जितेंद्र सामंतराय फाइल करचंदी वकालतनामा.
Yes, sir, Lord, sir.
देखी. All right, let's peruse the prisoner's petition regarding engagement of advocate Jitendra Samantray in place of N.N. Mahapatra at Flag C. Mr. Samantray has filed the wakalatnama which is accepted. The name of Mr. N.N. Mahapatra shall not be reflected in the cause henceforth. How can you
last case रे 883 मेलो 883 of 2000
कौन चाहूँगी
outdated फुटी है इधर आर्जन करिए
ये तो आसी automatically put of this matter along this one.
No, I.
आइए नहीं आइए नहीं तो खाली हमें खाली कोई दूसरी जे आइएटा से आइटम प्रथम आइटम रे अछि तो सीटा जितले लिस्ट हो ए दिटा भी ता संगे आसु या तो नेक्स्ट.
Item 70.
Yes, Mr. Tripathi.
On return section 302.
Agu reject है नहीं तो?
No.
Our deposition copy.
Alex.
कितने वर्ष रहे नहीं?
My lord, 7 years, 7 months.
The double murder.
Yes,
Double murder.
And my plea is that I was not present at the time of death. I was working at.
Double murder माने जाने उच्च अपन स्त्री.
My lord,
How did he?
ମୁଁ ନଥିଲି ମୁଁ my plea ହେଲା I was
ये काम कला.
my lord
अपन कुआड़ जाई स्त्री और झियो को छाड़ी दें.
ମୁଁ labor କାମ କରୁଥିଲି ଭୁବନେଶ୍ୱର. And there is no eyewitness to the occurrence.
केबे असले
ମୁଁ ଖବର ପାଇ ଆସି
केते दिन पर
ये खबर दला अपन को.
ଏଇ villagers.
केबे गले केबे आसिले.
Well, I have given VW to Lordship. I have given the evidence from my side, man. And they have disclosed that I was not present at that time.
You know, the dead bodies were found inside a stone cave in Commercialia forest. After 15 to 20 days of their murder. तो आपण स्त्री कुआडे गला झियो
मैं
कुआडे
मासे हेला मु थिली जाई भुवनेश्वर.
माने किसी खबर न नथले
ना they are tribal people, man. And
बागी how नहीं होगा.
Next question.